Commonwealth of Massachusetts. Court is open. Please be seated.
All right, well, good morning to everyone who's present here for the Monday, May 4th oral arguments. My name is Justice Walsh, and today the panel consists to my right of Justice Hershfang, to my left is Justice D'Angelo. We will be the three-member panel for all 6 cases that are being heard today. So with that in mind, I want to just take a moment to explain a few of the ground rules here. As I said earlier, we have 6 cases, so the panel will take a break after the completion of the 3rd case once that is submitted for approximately 10 minutes, and then we'll resume after the break for the following 3 hearings. As is our customary practice, each side has 15 minutes, and there is no rebuttal. If there are or is impounded materials, counsels, we ask you to be careful and refer to parties' names by either the pseudonyms or initials when appropriate. Finally, just so that everyone here is aware, all 3 panel members have read what you've submitted. 15 minutes goes by quicker than 15 minutes, right? And so it's your time, certainly, to make your best arguments. However, I just suggest to you that you really focus the heart of the matter, the most important arguments that you want us to consider. And for those who haven't appeared before the appeals court, we do have a time clock, and you'll see the green light start at 15 minutes. It will then go to yellow, which tells you that your time is coming close to an end, and then the red light will come on. When that red light comes on, certainly you can finish your sentence or your thought, but that will close out the 15-minute period of time allotted to each of you. Certainly if the panel members have any other questions, we can ask them at that point, but just so that you're aware of how that time clock, just keep a look-see right in front of you, and you'll get an idea of how the time is proceeding. And with that, we will begin today's hearings, starting with docket 25P0103 in the matter of A.H. Attorney Ennis.
Good morning. May it please the court. My name is Susan Ennis, and I represent A.H. To satisfy due process concerns, the court must strive to find the least burdensome or oppressive controls over the individual that fulfill the purposes of the mental health statute. The dual purpose is the protection of the person from others from physical harm and rehabilitation of the person. Here the purpose of the regulation and the statute was frustrated, where the judge incorrectly applied the regulation to find that A.H. suffers from a mental illness within the meaning of the regulation. So the regulations have been evolved and revised over the years to carefully circumscribe the individuals that can become subject to an order of involuntary civil commitment. And the legislature tasked the Department of Mental Health to formulate the regulation. And the regulation most recently was revised to include the DSM-5 as, a reference in that regulation. So there was...
Regardless of whether it's in the DSM, the definition of a mental illness is a substantial disorder of mood, right? Mm-hmm. So why isn't the fact that the hospital's expert testified that what the respondent suffered from was a substantial disorder of mood, isn't that enough? It's a question of fact, isn't it?
No, it's not a question of fact. The experts had an agreement that it was intermittent explosive disorder and autism spectrum disorder that he suffered from. The regulation requires a substantial disorder of mood. Now, the language means the condition must be primarily based in mood, and the effect on mood is a collateral effect. And if you look at the regulation, it has two separate parts. First, we have the substantial disorder of thought, mood, perception, orientation, or memory, which grossly impairs judgment, behavior, capacity to recognize reality, or ability to meet the ordinary demands of life. So the first part of the regulation defines the categories of mental illness that subject a person to involuntary civil commitment. Now, first of all, it has to be a substantial disorder, meaning primarily based in mood, which this was not. It was diagnosed as a conduct disorder, categorized in the DSM as a conduct disorder. So the judge's job was to correctly apply this regulation. So the first part of the regulation talks about the condition itself.
So can I just ask, to jump in for a moment, is your position that the judge, when you say the judge ought to have, right, is a judge constrained in interpreting the definition just to the DSM-5 kind of categories of?
Well, the DSM-5, as I said, was incorporated as a reference, and there was a filing with the Secretary of State when this amendment was enacted, stating that the DSM-5 categories were, the reason for one of the amendments was to update the terminology consistent with the DSM-5. So it appears that they clearly wanted to include DSM categories. And if I could just...
So I can appreciate that,
Yeah.
but can the judge look beyond what DSM-5 categories are in determining whether or not the testimony comports with the definition of a substantial disorder of mood?
I think that he should stay within the categories in the DSM-5. And also, if you look at the regulation, it has two parts. So the regulation first says it has to be a substantial disorder of thought, mood, perception, orientation, or memory. That's the first part. Then we talk about the effect of the condition, which grossly impairs judgment, behavior, capacity to recognize reality.
I want to slow you down for a second. Okay. I know your time is limited because there's more in the reg than you read, and I think it's important to look at the second part of that, of 27.051. So there's the portion you accurately read, and then it goes on to say, but shall not include intellectual or developmental disabilities, autism spectrum disorder, traumatic brain injury, or psychiatric or behavioral disorders or symptoms due to another medical condition as provided in the DSM. Is that the incorporation of the DSM that you're talking about, or are you talking about something different?
The incorporation meaning?
You say that the regulation was specifically changed to advert to the DSM.
Categories, just the categories.
Just the categories. So you're not talking about this language.
I'm talking about the categories of the DSM, the classifications, which is this, what we have in front of us. So Dr. Thompson's opinion went to the second portion of that regulation, which is the effect on the mood. Now, you can't consider the effect on the mood in conjunction with the first portion of that regulation, which defines the condition itself. So in other words, she said, well, it affects his mood. Well, that would be prong 2 of the regulation, not prong 1. So prong 2 asks you to consider the effect of that condition. And her opinion regarding the effect.
What if Dr. Thompson had said, instead of saying, the question was, is intermittent explosive disorder actually an impulse control disorder? It is. Yeah. And so by definition, does that mean it is not a mood disorder? Well, in his case, it can be a mood disorder. So if he had said, well, in his case, it can be a substantial mood disorder, that would put it into category 1, wouldn't it?
No, because if you could just repeat that.
Sure. His answer was, well, in his case, it can be a mood disorder. Under this definition, if he had said it can be a substantial mood disorder, that would have been in category 1 of the definition, wouldn't it?
She's still talking about the effect of the condition. She's not talking about the actual condition. She's talking about the effect of the condition.
How do I know that based on the doctor's answer? The doctor's answer, well, in his case, it can be a mood disorder because it affects his mood.
And any number of conditions can affect the mood of a person. You know, you have a bad day. Does that mean that you're subject to involuntary commitment? I suggest no.
Well,
I
what
mean,
if
you
it's
have-
a substantial mood disorder?
Well, in this case, if she's saying it's an effect, it's collateral. It's not a substantial disorder of mood. It's a collateral effect.
That's
It's not
what-
substantial.
This is my question, counsel. That's what you're saying. But the hospital's expert didn't say that. The hospital's expert said it can be a mood disorder because it affects his mood. If the judge credits that, that's a question of fact.
I would suggest it's a question of applying the regulation, which the judge in this case incorrectly applied.
So
Because-
is your position that this particular disorder could not be the subject of civil commitment, period?
Right. It's not. It's a conduct disorder. It's purely impulse-based. If you look at it, all of his behaviors are based on impulse. So he has angry outbursts. Now, anger is not a mood.
And you're
Anger
basing
is
that
an
on the
emotion.
fact, you're basing that on the fact that that's what the respondent's expert testified to, right?
No, I'm saying that number one, it is not it's a collateral effect, what she was saying about the mood disorder. So that doesn't fit within the parameters of the regulation, first of all, because she's talking about the effect, not the condition itself. So the condition, and as I said, it was two different parts of this regulation. So it's the condition and the effect. So first we have the condition, and she's saying, well, the effect, but she's considering the effect under prong one, which she shouldn't be doing. And the judge should have correctly applied that regulation by saying, well, you know, it should be a substantial disorder of thought, mood, perception, orientation, or memory. Now, it's not a substantial disorder of mood if it's merely a collateral effect of it. She's saying it's merely a collateral effect because it affects his mood. So we have to look at the substantial portion of it also. It must be primarily based in mood, as I said.
And in your argument hinges upon us accepting that the judge is limited to making a categorization that intermittent explosive anger disorder does not fall within the DSM-5 category.
Well, I'm also saying that it was her testimony regarding, her testimony went to the collateral effect, which is, I would say, not just, you know, limited to the DSM-5 category. She's talking about the effect. And if she's talking about the effect, that's collateral. That's not substantial disorder of mood. It's not primarily based in mood. And it also goes to the second prong of that regulation, which is the effect. And you can't consider the effect under prong one. So the prong one talks about the condition, prong two talks about the effect. And the DSM categories are, as I said, referenced, so we have to consider the DSM categories, which is a conduct-based disorder. If you look at the evidence, it was overwhelmingly conduct-based. I mean, it was basically outbursts, you know.
On direct examination, the question is, and as it manifests itself in Mr. H, is IED a substantial disorder of moods? Answer, yes. In a light most favorable to the petitioner, why isn't that enough? The judge accepts that answer.
Yeah, but the judge incorrectly applied that regulation, didn't look to the DSM categories, and didn't look to the language of that regulation.
Where is that in the record, that the judge didn't consider that?
Well, when he said that he credited her testimony, and when he said he credited the reading of the Del Verde, which I would suggest is also wrongly decided. So the Del Verde matter, I would suggest, is also wrongly decided because it included the effect in the
Well,
prong one,
Del
which
Verde
is
is
not.
a Supreme Judicial Court case, so we are bound by it. I think you have a better argument than saying it's wrongly decided, which is that in that case, the person to be committed had been diagnosed with depression, which I think even a layperson could recognize as a
It's mood disorder.
substantial mood
Exactly.
disorder.
That is a mood disorder, exactly. And that is what I presented in my brief. So obviously, depression is a mood disorder, and I did present that in my brief. And in this case, we have a conduct-based disorder. And as I said, the regulation does look to that DSM-5. So I think we should limit ourselves to the DSM-5 categories. And it says it's not a mood disorder, it's a conduct-based disorder. So we can't get to point B unless we get to point A, unless we satisfy point A. So if it's a conduct-based disorder within the categories of the DSM, and I would suggest that we should limit it to the categories of the DSM-5.
Do you
because
include
they were
those portions of the DSM-5 in your addendum? I'm not seeing them. You keep saying what they say, but I'm not sure that I have them in front of me here.
Well, even the testimony said it was a conduct-based disorder, an impulse control. So he has no control over his impulses, which is what precipitates the behaviors. It's not mood, it's, impulse. It's impulse-driven. The testimony of the experts bore that out. They both agreed that it was conduct-based, not based in mood. So if the experts are saying that it's conduct-based, it's impulse control, then we don't get to prong 2. We don't satisfy prong 1, which is the condition itself. So
I take it your client has been released?
no.
Okay.
He's been continually committed, which is another issue, which I believe I also presented in my brief, much like the Jackson v. Indiana, which I use as an analogy. So he's been continually recommitted based on, this finding of mental illness, where he's clearly not mentally ill, and he's not mentally ill within the meaning of the statute, the regulation, and he's continually committed.
Well,
DMH.
he's not continually committed because of this commitment. It's a recommitment where a new judge has had a new hearing, and presumably, and I think we're going outside the record, but presumably a judge has made the same decision.
I honestly don't know but he's been recommitted based on a finding of mental illness when he clearly doesn't have a mental illness. He's not being properly cared for. He can't get the proper care. He'll never satisfy rehabilitation because he will never be rehabilitated where he is. Both experts agreed that he will never get better where he is. He needs DDS and services. DDS services are the only ones that can actually rehabilitate him. Where he is now, he will never be rehabilitated. He will always be sort of warehoused in a mental health facility,
So I
which
see
is
that-
against due process.
Okay, I see that your time is up, so we'll have to leave it there.
Thank you.
Thank you.
Good morning. Alexander Weiss from the Attorney General's Office for the State Petitioner. This court should affirm the district court's commitment order because there is sufficient evidence in the record to establish, beyond a reasonable doubt, that first, the appellant's IED diagnosis constitutes a mental illness under department regulations. Second, appellant's discharge would pose a likelihood of serious harm to himself and others because of the violent behavior appellant exhibits as a result of his disorder. And third, there is no less restrictive alternative to civil commitment by which to treat appellant, which would sufficiently protect appellant and others from his dangerous behavior.
I don't hear the appellant to be arguing the second and third points at all.
In appellant's brief, the appellant does argue the third point, but I agree that the second point is conceded, that appellant, his dangerous behavior poses a risk of physical harm to others.
So how about this DSM issue? I mean, I guess you don't, but what is the reason that you think that there is a path other than the DSM for defining a substantial mood disorder?
So I think there's really a number of arguments which indicate this argument doesn't work. First is, as Your Honor mentioned, the Supreme Judicial Court case in Del Verde. It is true that the disorder in that case was adjustment order with depressed moods or depression. However, the Supreme Judicial Court at no point in that decision made reference to the categories in the DSM. The Supreme Judicial Court did not indicate that its categorization was constrained by the DSM's categories. Rather, the Supreme Judicial Court held that the individual's depression constituted a mental illness solely because expert witness testimony suggested that the symptoms were severely affected the individual's mood and behavior. So that shows that this theory that a disorder of mood, that a disorder cannot be a disorder of mood if the mood is an effect of the disorder really fails under the Supreme Judicial Court's holding in Del Verde.
I don't think Del Verde helps you that much. The reason that I think that is that I think it doesn't take an expert to understand that depression is a mood disorder. And so the fact that the SJC didn't feel the need to search more broadly to draw that conclusion seems sort of neither here nor there in a case where we're talking about something that is a lot less well-known and that I think is often associated with things that are explicitly not mental illnesses like autism spectrum disorder.
So I would disagree with Your Honor's reading of Del Verde. I think in Del Verde, first of all, there was dispute about whether the individual's disorder was a mental illness. I believe 2 of the expert witnesses in that case argued that because the depression wasn't severe enough, it didn't constitute a mental illness. But further, I think it's important to look at the court's reasoning that they used. It is true that the layperson would, I'm sure, understand depression as a mental illness. However, the court's reasoning was not that the layperson would understand that it's a mental illness. The court's reasoning was that that individual's particular disorder severely affected their mood and behavior. And I would further note that I would guess a layperson would associate intermittent explosive disorder once they hear the symptoms that it involves as a mental illness. So I think that sort of reasoning works both ways.
But just because it's a mental illness, right? So in a hypothetical, if an individual is diagnosed with kleptomania, right? Is that going to be the subject of a civil commit?
No, and I think...
So just because it has to be a particularized mental illness that
Yes.
meets the category, and I'm not saying the category of DSM-5 necessarily, your argument is that it's broader than that. But there certainly seems to be an element of a substantial disorder of mood.
Yes, kleptomania might or might not, I'm not sure, fit into one of the other categories of thought, perception, orientation, or memory. But there are other constraints imposed on the scope of a mental illness in the definition, namely that it needs to grossly impair the individual's judgment, behavior, or capacity to meet the ordinary demands of life. So for that reason, I don't think there's a concern here that the inclusion of intermittent explosive disorder within the category of mental illness would somehow bring in all of these other things where it's a little more dubious whether it fits the definition. I would also want to point this court to a previous decision by the Appellate Division of the District Court, matter of AL, which I cited in my brief, where the court specifically held, based on expert witness testimony, that impulse control disorder constitutes a substantial disorder of mood. So this is not unprecedented, this notion that an impulse control disorder can constitute a disorder of mood. I would also point this court to the various parts of the definition of mental illness, which I really don't think fit together coherently under appellant's reading of the regulation. Under appellant's reading of the regulation, the first half of the definition sets forth narrow categories from the DSM that would be included in the definition of mental illness. But if those categories are narrow, then the second half of the regulation serves no purpose, because it excludes from the definition of mental illness these various disorders that don't fit within the DSM categories that that according to appellant comprise the entirety of the definition of mental illness. So I think that this reading that the definition of mental illness refers to these particular DSM categories really has to fail because it fails to provide a coherent story about how the pieces of the regulation fit together.
Is there any exception that if, under the regs or the definitions, that if an expert testifies to, quote unquote, the illness severely affected his behavior and mood, that that's the end of the story? If the judge accepts that, it's a mental illness under the regs. Is there any exception to that?
Yes, I would say if there was not also evidence to support that it grossly impaired the individual's judgment, behavior, or capacity to meet the ordinary demands of life.
No matter what DSM says, if an illness fits what I just read along with what you just read, and an expert testifies to it, that's it.
If the district court credits that expert testimony, yes, I would believe so. And I think Del Verde really requires that holding, given the Supreme Judicial Court's holding in that case. So given this definition of mental illness, I would love to go through why Dr. Thompson's testimony really supports that the appellant's symptoms in this case meet the definition of a mental illness. As it goes to the mood prong of the definition, Dr. Thompson explained that appellant's outbursts, which caused appellant to have uncontrollable violent behavior, are characterized by extreme anger. And Dr. Thompson testified that that constitutes a mood. I know that that the other expert witness disagreed with that, but the district court was not required to credit appellant's expert witness. That also comes from Del Verde, that we don't need unanimity amongst the expert witnesses on any issue here. As far as whether the disorder grossly impaired appellant's judgment, behavior, and capacity to meet the ordinary demands of life, I think it's clear that having uncontrollable outbursts that entail assaultive behavior impairs one's judgment and behavior. The expert witness, the hospital's expert witness also testified that this disorder causes appellant to be unable to take care of himself with regards to hygiene issues, and that he also requires one-on-one supervision when he eats in order to avoid a choking risk. So for all of those reasons, I think it's clear here that appellant symptoms cause him to meet the definition of a mental illness.
What about the last prong about
Yes.
that he should really be in DDS?
Yes. So the issue here is under matter of minor, a Supreme Judicial Court case, that about whether there is a viable, plausibly available option that brings the risk of harm below the statutory threshold. And the hospital's expert witness testified that she did not believe such an option was available. And that is really enough. If the district court credits that testimony, that is enough to satisfy this prong. I would point this court to the Supreme Judicial Court case, matter of MC, where there was very similar testimony, and the court held that that was enough. As regards to DDS housing, the hospital's expert witness testified that DDS housing would not provide sufficient protection, that they do not have the resources to adequately restrain the sort of assaultive behavior that appellant exhibits. And further, she testified that the Department of Mental Health had tried to explore DDS housing, and DDS had decided that it would not be safe to house appellant in DDS housing, which seems to be a reasonable conclusion given appellant's persistent assaultive behavior. And appellant makes an issue of this criteria that DDS set forth, that appellant, in order to be transferred to DDS housing, would have to go 3 months without a physical hold or mechanical restraint. But as far as I can tell, that's an entirely reasonable criteria to impose as a way of allowing appellant to establish that his behavior has changed, that he has improved, and that he would no longer pose a threat of physical harm to those around him if he were placed in DDS housing. I would also point to appellant's expert witness, who he did testify that there were other options available, but I don't think that his testimony stands up to scrutiny. In particular, he testified that appellant could be transferred to a DMH respite, which is a temporary, short-term based service that is based in the community and that enables the individual to exist in the community. Even under appellant's expert witness's testimony, that is not an acceptable option, because as he testified, a DMH respite would not provide the sort of structured environment with 2-to-1 staffing that is required to adequately restrain appellant's assaultive behavior. The expert witness also went on to testify that, well, the DMH respite would be temporary and another option would open up because DDS and DMH would be so desperate to house appellant somewhere. There are a few problems with relying on that testimony. First of all, the expert witness testified that that was an entirely speculative notion. He said there was no guarantee that this option would open up. Further, even if it were true that another option would open up while appellant was in the DMH respite, it would still require appellant to be housed in the DMH respite for a temporary period of time, which would pose an unacceptable risk of physical harm to the others at the respite and to appellant himself, given the self-destructive nature of much of his behavior. And third, the expert witness did not testify that this option that would open up would meet the statutory threshold of safety. Rather, he testified that DMH and DDS would find the safest available option, but there's no evidence in the record to establish that this option would be safe enough to protect those around appellant and appellant himself from his dangerous behavior. I'd also like to briefly discuss the issue of rehabilitation. I strongly disagree with appellant counsel's characterization of the record on this issue. The hospital's expert witness testified that there is plenty of hope for appellant to be rehabilitated while he is housed in the facility. She specifically stated there was hope given changes in his medication regimen, and that in his 6 years at the facility, his behavior had improved dramatically, that the frequency of his outburst had decreased from almost on a daily basis to being on a monthly basis. I further want to note that even if if there were no prospect for appellant to be rehabilitated at the facility, the fact is that the court really had no option here. If appellant would pose a risk of physical harm to those around him and to himself in any other context, then even if it's incredibly frustrating to the appellant that he has to remain housed in the facility, the fact is any other option would just pose an unacceptable risk of harm to others. And as Your Honor has noted, it's important to note that there has to be a hearing under the statutory provisions at least once a year to re-examine whether appellant still continues to pose a risk of physical harm to himself and others, such that commitment is the only viable option. And then on appellant's, moving on to appellant's federal due process argument, I think it's pretty easy to dismiss this argument just because the Supreme Court decision that appellant cites, Jackson v. Indiana, really goes to a situation where the individual does not receive any sort of civil proceeding such that the court doesn't make a decision on whether the individual has a mental illness or whether they pose a risk of danger. Here, that is clearly not the case. The civil proceeding involved decisions on both of those issues, and under the Supreme Court jurisprudence, there is no due process violation here accordingly. And I would point this court to Fuchsia v. Louisiana, where the Supreme Court specifically said that as long as such a civil proceeding occurs, the due process clause is adhered to. If there are no further questions, I'll conclude by asking this court to affirm the district court's commitment order. Thank you.
Thank you. The case stands submitted. Very nice argument by both. Thank you. The next case up will be DIGINOVATIONS versus Wales and others. Good morning. Attorney
Good morning,
Engel?
Your Honor. Members of the panel, may it please the court, my name is Justin Engel, and I represent the appellants Wales, Christopher Mackos, and Endeavor Films. We are here today because Mr. Wales has been found liable for breaching a restrictive covenant agreement that never existed. The plaintiff never produced a copy of the alleged agreement. No witness testified that my client...
Interrupt for a moment.
Yes.
Okay. We're no longer at trial, and respectfully, there's a lot that was presented on appellate argument, but the day of the jury trial has long gone by, and so our view, as you understand, is looking to see what error, if any, occurred, and if so, what the remedy is. So, kind of shaping the facts doesn't help. What would help is first to explain why so many of the issues that you argue on appeal and didn't object at trial aren't considered waived. If you could jump to that issue, that would be helpful to you.
Well, so in terms of the issue of whether or not there was an executed non-solicitation agreement, that issue was repeatedly raised at trial and objected to. And that's the fundamental issue in the case. I think there has to be evidence, in order for there to be a breach of a non-solicitation agreement, which is the core claim in the case, there has to be evidence that there is a non-solicitation agreement that actually existed. It's our contention that this claim never should have gone to the jury in the first instance.
Because they couldn't produce the actual document.
Well, not only
Because
because
there was,
because they couldn't produce the actual document, and also there was never any testimony. There still has to be sufficient evidence presented at the trial to meet the elements of the claim. No one testified that Mr. Wales, that they had ever seen, that the agreement was ever sent to him, that he had ever signed the agreement. There was absolutely no manifestation that Mr. Wales ever assented to be bound by a non-solicitation agreement. And we do think that that was a legal error, and that claim should never have gone to the jury in the first instance. And part of the reason, Your Honors, for that is there is over 100 years of case law holding that restrictive covenants are narrowly construed. They restrict freedom of employment. They restrict client choice. It's our contention that there does need to be a clear manifestation of assent to be bound by a restrictive covenant agreement. That is an issue that was objected to repeatedly, and it never should have gone to the jury in the first instance. We have not found any case in Massachusetts, or really anywhere for that matter, that implies the existence of a post-employment restrictive covenant agreement from
Why isn't it a fair inference that the jury could draw about the testimony that every employee that worked there had these covenants? We just can't find this one. Why isn't that a fair inference that the jury could say, well, if every other employee had one, then this person must have also?
Because the burden is on the employer to show that the employee assented to the agreement clearly. In the non-compete statute, there's actually a requirement that the employer produce a signed agreement. And we believe that same principle should apply here. And the issue is, if there had been testimony where somebody said, yes, Mr. Kolowitz or some other witness testified, yes, we recall sending the agreement to Mr. Wales, we recall him executing it, and then we just can't find it, we would have a different case. That's not what happened
So
here.
what was it about the adverse inference instruction that you think took that finding of fact away from the jury?
The adverse inference instruction allowed the jury to infer that Mr. Wales that there was an agreement that existed at some point in time that he signed, that he clearly manifested his intent to, and that he then deleted, either deleted electronically or somehow went into a paper file in an office and destroyed the agreement. But there was no evidence that anyone ever testified to where, yes, I put that, he signed it, and I put it in the paper file.
I understand your argument about the separate obligation and burden to show some sort of evidence that this agreement occurred. But on the specific instruction to the jury, unless I missed it, I didn't see an objection.
So it was objected to repeated. So the adverse inference instruction flowed from an earlier decision in the case. It's our contention as well that the spoliation sanctions that were awarded, which were repeatedly objected to in writing, there was an objection. There was.
And I read what you provided in the claim that the special master exceeded the bounds and the judge didn't make an independent finding, but I'm looking at record appendix 3, page 3,789 to 90. I don't see where it seems like there was an agreement to the spoliation instruction to the jury. So it's difficult for me now to understand when at trial, there's no objection, how we as a panel reached that issue.
Well, I think that it can be reached under, based on the fact that it was trial counsel's objection from the very beginning in objecting to the way that the spoliation hearing or the spoliation decision was reached in the first instance. He did not renew the objection to that at trial, but it's still our contention that you can reach that issue.
A case to support that position, that if an attorney earlier objects but at trial doesn't?
I believe we cited cases in our brief that said that discovery rulings that were objected to can be raised on appeal. I don't have it in front of me, but it is cited in our briefs. I believe we cited 2 cases for that principle.
Can I just ask for a moment, jumping to, do you agree and concede that there was a breach of a fiduciary duty?
We are not objecting to the fiduciary duty claim, that's correct.
So,
You mean you're not appealing it?
We're not appealing, yes.
okay. So if that isn't the basis of an appeal, can we speak for a moment about your claims of damages and otherwise? Because with that breach,
So, Your Honor, I would point you to the Ayash decision, which is cited in our brief. So in the Ayash decision, what happened here with respect to the jury form, so it's our contention first, there was a lump sum awarded on contract damages. There was a lump sum awarded in tort damages for all of the tort claims. It's our contention that there can't be a breach of contract claim against Mr. Wales. On the tort claim, the Ayash case is directly on point here. What happened in the Ayash case is exactly as happened here. The jury awarded damages on 3 claims in an undifferentiated lump sum. The SJC vacated the jury verdict with respect to 2 claims, upheld the 3rd claim, and said that they remanded for a new trial on damages. And the reasoning, which is our contention, applies with equal force here if Your Honors agree that one or more of the tort claims is defective. What the SJC said is, on this record, it is impossible to ascertain the amount of damages the jury assessed for the retaliation claim. In such a situation, with the damages on 3 claims, 2 of which are invalid, 1 of which is sound, awarded in an undifferentiated lump sum, there must be a new trial on damages. That case, it's our contention, is binding, and that case is not addressed by opposing counsel at all in their briefs. This court, in an unpublished decision, reached the same conclusion in the case of Thing versus Duca. There, the court also remanded for a new trial on damages, where the jury didn't separately calculate damages for the plaintiff's claims, one of which was found to be valid, the other found to be invalid, and the court relied upon the same reasoning in that case. Again, these cases are not addressed, and we would contend that they are controlling precedent here.
Can I go back, I guess, sort of to the waiver argument? The judge held that an adverse inference instruction was appropriate as sanctions for the destruction of evidence. I know you don't agree with that, but that's what the finding was. Your client never proposed what the adverse instruction should be. What are we supposed to do with that? I mean, the judge made a decision, an adverse inference instruction was appropriate. And there was a special master version that was actually worse for your client, I think, and you never proposed anything. And there was no objection, as Justice Walsh said. So what are we supposed to do?
Well, I mean, we would contend that if the case were to be remanded, there should be an evidentiary hearing on the appropriateness of a spoliation instruction at all.
You never asked for an evidentiary hearing on that.
It was requested, so I was not personally trial counsel, but trial counsel did request an evidentiary hearing before, when he objected to the discovery master's recommendation. He objected to it both before, I believe he requested it before the discovery master, but he definitely requested it and objected to the discovery master's
even after he objected, he never made a proposal as to what the adverse instruction should be.
And I believe,
That issue waived then, it's,
I believe, like, if it were to be reached, it would be our contention that that there was no basis for an adverse instruction at all, or at a minimum, there needed to be some independent determination by the trial judge, and we would contend an evidentiary hearing on that issue. But even with the adverse inference instruction, again, even if your honors don't reach that issue, we would contend with respect to the contract claim and with respect to the trade secret claim, the adverse inference instruction isn't enough for the plaintiff to meet their burden of satisfying the elements of the claim, because you have to show that there was, in order for you to be able to draw an inference based on destruction of evidence, you have to show that there was relevant evidence that actually existed. We cited case law in our brief for that proposition. No one ever presented any evidence that this non-solicitation agreement ever existed in the first place. So for that reason, even if your honors decide that the any objection to the adverse inference instruction is waived, it's still our contention that the contract claim and the other claims that we appeal on should be reversed, and a new trial for damages should be awarded.
Can we jump for a moment to the joint and several argument between MACOS and Wales? What's your thought on, I mean, I understand what you want, but you're generally, and you agree that when there are two tortfeasors and they've been found liable, joint and several theory applies, right?
We recognize the general principle of joint and several liability. We believe the case law supports, again, the IASH case, supports the principle that where damages are divisible and where there is a specific jury instruction or verdict form which has the weight of a jury instruction, it directs the jury to apportion damages, and then the jury apportioned damages, that takes you out of joint and several liability. The IASH case found no error where the jury apportioned damages between multiple defendants, and they found that joint and several liability did not apply in that circumstance.
Isn't that,
Go ahead, sorry.
isn't that a real problem when you get to your argument that the jury awarded duplicative damages to Mr. Wales and to Endeavor, and that instead of each being liable for $558,020, they should collectively be liable only for that amount?
Well, the difference there, Your Honor, is that Mr. Wales essentially was synonymous with Endeavor because he is the sole owner of Endeavor. Endeavor could only act through him. Mr. MACOS, we would contend, so essentially the damages between Wales and Endeavor are not divisible. The damages with respect to MACOS
The
and
jury
Wales,
divided them, and you just said that the jury verdict form has the force of jury instructions. And so as I look at the pages of the verdict form, you know, your argument has a certain facial appeal. It's the same amount. They're basically, you know, maybe alter egos of each other, or Endeavor is Mr. Wales's, you know, corporate alter ego. But then the jury's asked to total damages as to all defendants. And when you look at that, they've still split out Mr. Wales's damages from the Endeavor damages. So how do you suggest that's consistent with the argument you're making?
and the reason, Your Honor, is because if you look at the three defendants were in much different positions. In order for joint and several liability not to apply, the damages have to be divisible. As between Endeavor and Wales, it's our contention the damages are not divisible. As between MACOS, MACOS is in a much different position, both at DIGINOVATIONS and at Endeavor. He was an employee. He did not set up a competing enterprise. His position is much different vis-a-vis Mr. Wales, and that's why the damages are divisible as between him and the other defendants, and that's why joint and several liability should not apply to him. And I would just ask, my time is up, but in conclusion, appellants respectfully request that the jury verdict be reversed and a new trial be ordered on damages and DIGINOVATIONS cross-appeal be denied. Thank you very much.
Attorney Phillips.
morning, Your Honors. May it please the Court, Amanda Phillips for DIGINOVATIONS, and with me in the gallery today, Mr. Michael Kolowich, who is the founder of DIGINOVATIONS. The verdict stands on independent fiduciary duty and tort grounds, fully supported by the record. Those are unchallenged on appeal. The adverse inference instruction was not the basis for the verdict. It simply allowed the jury to evaluate the gaps created by the defendant's destruction of evidence. The jury did not need that inference to find liability. It confirmed that inference confirmed what the evidence already showed.
Where in the record is there from your clients or any witness that there was actually a written non-compete agreement?
Mr. Kolowich's testimony, he testified that it was the standard non-compete used for every employee. It had not changed in many, many years.
But your client did not provide any specific agreement as to the defendants, correct?
Yes, the defendants destroyed massive amounts of evidence.
I understand the defendants destroyed their own emails.
Yes.
So I guess if you look at email in a chain, I think we can all, one is the sender, one is the receiver. They destroyed the receiver. Shouldn't there have been evidence presented from the sender that an agreement went to the defendants?
Your Honor, there were, I don't believe that email exists. This was back in 2010, 2011. Mr. Kolowich had conversations with Mr. Wales. Mr. Wales acknowledged that he had signed all of the paperwork that was required. This was before a time, I agree with Your Honor that in today, in 2026, you would expect that email to exist. In 2010 and 2011, I would not necessarily expect that email to exist, Your Honor. Moreover, there were paper files in the business manager's office. There's testimony on the record about these paper files, and Mr. Wales was seen in the 2 weeks before he resigned going into that room, bringing out sheafs and folders of papers, rifling through them at his desk, and returning papers to the business manager's office. The business manager's office is where all of the employee files were kept, and when Mr. Kolowich and the business manager looked for Mr. Wales's employment file, it was gone. So, Your Honor, that is certainly sufficient for the jury to infer that there was a written contract and Mr. Wales destroyed the paper record of it. And again, we're talking about 2010, 2011 when, Your Honor, when Mr. Makos and Mr. Evers' agreements were put into evidence, there was an email about those only because Mr. Kolowich was reminding them of their obligations and he scanned it and emailed it to them. I don't believe there were ever, electronic copies of these. The practice was to have them in paper form in the paper files. Your Honor, I'd also like to address the instruction was well within the trial judge's discretion. In fact, she gave a narrower instruction, as Your Honor's recognized. She gave a narrower instruction from what the motion judge had requested. And so Your Honor is exactly right about the waiver point. And I would add that, they're appealing an instruction that wasn't given. If they're appealing that original order, they're appealing an instruction that was not given. The instruction given was permissive, not mandatory. It allowed the jury to make the inference, but did not require it. And given the difference between the motion judge and the trial judge, you'll see me on the record objecting to it at the time, and that is the subject of our cross appeal. But that demonstrates that the trial judge was well within her discretion. When you have two sides arguing about two different, reasonably arguing about two different versions of the jury instruction, then that suggests, Your Honor, that it's well within the trial court's discretion.
Can I divert you for a moment, just because there's so many arguments and so little time, to ask you what you are asking for when you cross appeal about the joint and several liability? It's clear to me that your client is looking to have Mr. Makos added in, but I couldn't tell from the argument whether that was, added in where and why, and then how about your friend on the other side's argument that there are duplicative, that because Wales and Endeavor have sort of the same corporate persona, that those awards are duplicative or joint and central, several or both.
Okay. Your Honor, several questions there. I'll try to address each one. DIGINOVATIONS is asking that as a matter of law, on the verdict form, it says Mr. Makos caused damage. And joint and several liability flows from that finding of liability. There's some allocation and math on the jury form. That is just elevating form over substance. He's liable jointly and severally for the full verdict because he jointly and severally caused this harm. And I would add, Your Honors, that appellants are using the wrong standard when they suggest that Mr. Makos was not a full participant or was somehow lesser involved. That's interpreting the evidence in the appellant's favor incorrectly. The evidence must be interpreted on appeal in DIGINOVATION's favor. And the evidence shows that Mr. Makos was more than just some random employee. He was the second in command at DIGINOVATIONS.
Counsel, I might agree with you on all that.
Okay.
But how do we ignore the jury special verdict form where they're not assessing any, well, a little bit of money to Mr. Makos? I mean, I don't think there's any case law that says we can just ignore the jury's finding on that issue.
So joint and several liability is a matter of law. Yeah. And giving the joint and several liability, and I objected to this in the record, giving the question of joint and several liability to the jury is allowing the jury to rule in a question of law improperly.
So I don't disagree with some of what you said, but the fact of the matter is that your argument, if we accept it, is once the jury checks off the box that Makos did this, right, and Wales also did this, then they're immediately, as a matter of law, on the hook for joint and several liability, regardless of the instruction of, first of all, independently consider the evidence against Wales, independently consider the evidence, whether they're liable. Secondly, on damages, independently look at Wales, independently look at Makos. And they did. And night and day as to what the jury believed. And by the way, I didn't see, again, an objection to the verdict form on dividing the damage portion, right? It wasn't just damages plunk, because as a matter of law, once you check off the box that both Makos and Wales are liable, then it's one big pot, right? So one, you asked for it, and that's one of the swords that we live by. Careful what you ask for. Now, secondly, it does seem like the jury was able to take this apart. Sure, as a matter of law, generally, joint and several, except when cases can be such that damages can be ascertained. So is that your position? Once they check off boxes for liability for the two, as a matter of law, it's joint and several?
Your Honor, in this specific case, the jury was instructed many times not to double count. And that, because they were instructed not to double count, they allocated the damages in certain ways because they were being careful jurors, not double counting, right? That is what you see on the verdict form. It is not the jury saying that Mr. Makos should not be subject to joint and several liability, which is not the jury's province to say that. I will say that there are cases in the record, Fuller versus Chamberlain. It's an old case. It's from the 1800s, but it's good law, and it illustrates the example where the judge, they had a verdict with separate amounts for each tortfeasor, and the judge said, no, it's one amount for the whole tortfeasor. And here, I would say that Mr. Makos's participation in the scheme, Mr. Wales has testified that he could not have done this without Mr. Makos's help. It could not have happened without
But
Mr.
if we look at it as a matter of law, then as a matter of law, blinders on about how much, how bad, how together they were, as a matter of law, then they're on the hook for both, regardless of 10% or 90% bad, right?
In this case, yes.
Okay, but had you could have drafted a jury instruction, in hindsight, right, or a verdict form, in which it was are Wales and Makos liable? If so, what is the total amount of damages? And if not, if you find one or the other, could you have done that?
We requested, we objected to this verdict form. We objected to the verdict form, and I specifically said that it could create confusion on appeal about the nature of damages. So
Can you point, again, I apologize, but there are, I think, 9 volumes of record appendix. We all may have missed it. Where is your objection specifically to the special verdict form and that issue about apportioning damages?
I'll have to use some of my time to find that record site. I know
You
it's
can
there.
submit a Rule 16 letter if you want.
I will.
Thank
I will,
you.
Your Honor. The other thing that I would point you to, Your Honor, is on damages. We have a chart that was presented to the jury. It's in the record at RA 7-109. Sorry, RA Volume 7-109. The damages from this scheme, this endeavor, was lost profits and revenue that was diverted to Endeavor Films. Mr. Wales and Mr. Makos both testified that Mr. Makos worked on every project for every client for Endeavor Films. That revenue, that is that amount of damages, would not be possible without Mr. Wales and Mr. Makos diverting those clients and then working on every project for every client. They testified that Mr. Makos worked on every project for every client. And so he was...
It just seems counterintuitive when a jury says just 1,000, for you now to come back and say,
Yeah, I understand,
gonna
Your Honor.
set that aside.
I understand, Your Honor, and I don't want to belabor the point, and I understand Your Honor's position. I would say that we objected to this in the record. We did, and I will send the Rule 16 letter.
Let me, I don't know if anybody would want this, but let's say we agreed on that issue alone. What do we do? Does it remand for another trial on damages only?
No, Your Honor.
What happens?
Your Honor, it would be
Just joint and several the entire amount and then
remanded. Yes, Your Honor. And they concede that joint and several liability attaches to Wales, Mr. Wales and Endeavor Films. And why not Mr. Makos? And they concede the point with Mr. Wales.
Well, because of the corporate identity thing. I mean, it may or may not be a good legal argument, but they're not conceding it.
I would argue that Mr. Makos was as integral to Endeavor Films. And Your Honors, I also wanted to highlight, and I think you suggested this in your questions, that there's a breach of fiduciary duty that is unchallenged on appeal.
How does that affect your award for contract claims?
So our position is that the contract claim should be upheld. There's massive destruction of evidence in this case, and the defendant should not be allowed to profit from the massive destruction of evidence. The rule behind adverse inference and spoliation cases is that destruction of evidence, knowing that litigation is pending, has a pernicious effect on the truth-seeking function. So you don't need to reach that. You can. I'd love it if you did, but you don't need to reach that.
why not though? So
Because the breach of fiduciary duty supports the entire verdict in all of the damages. If you look at our damages chart on, again, that's volume 7, 109, this is what we presented to the jury. The damages are lost profits for the breach of fiduciary duty and for contract claims. It's the same damages.
You only have 10 seconds, and I'm
No.
going to throw a question. I'm sorry.
So
The judge, hold on. Do you agree, two-part question, do you agree that the special master exceeded the authority? And number two, if the master exceeded the authority, doesn't the judge have to hold some type of hearing to figure out whether there was a discovery violation and what to do about it?
No, Your Honor. The hearing is entirely discretionary. The rule plainly says that it's discretionary, and you're reviewing for abuse of discretion. All of this was testified under oath in depositions and in emails from the defendants themselves. And so it's pointless to hold a hearing, and the judge was well within her discretion to not drive up more legal fees by having an unnecessary hearing. If the discovery master exceeded his authority, the judge corrected that because she, in her order, reviewed all of the evidence. Again, deposition testimony. She reviewed all of the evidence. She's in as good a position as the discovery master to read deposition testimony and make a ruling on it.
All right, I see that our time is up. We'll have to leave it there. Thank you. The case is submitted. Very well argued. All right, the next case is 2025P0945. Is it Scribner versus Dudy?
Who said Duty?
So before we begin, just because we have two individuals that are pro se, that doesn't happen very often, and I would have otherwise mistaken you as attorneys. Otherwise, you look fully prepared and professional. I just want to remind you both, probably that you're already aware, if we can just refer to child as child, that would be helpful as we go forward, just to ensure that we're maintaining confidentiality and privacy of your own. So with that, Ms. Dudy, we have 15 minutes, the clock will start, and we'll be ready for your argument.
Sure. Good morning, Your Honors. May it please the Court, Sarah Dudy, self-represented appellant. This appeal presents two issues involving legal error and findings not supported by the record. The first is whether the trial court had the authority to enter an amended judgment after the notice of appeal. The second is whether the child support order complies with Massachusetts guidelines and is supported by the record. After the notice of appeal, jurisdiction transferred to this court, and the trial court no longer had authority to make substantive changes. The trial court then reduced weekly child support and changed the income threshold. Those were substantive changes, not clerical corrections, and the court lacked authority. The motion was also not properly served. It was sent to my prior counsel after I had already filed motion of pro se. I did not have the opportunity to be heard. I raised those issues in a motion to vacate, but there was no ruling on the merits. The amended judgment should therefore be vacated. Aside from that, the underlying judgment contains legal errors. The order misapplies the guidelines. It fails to account for a substantial portion of father's income reflected in the record, including bonuses and other compensation. Additionally, it limits income to W-2 Box 5, which does not capture full scope of income required under the guidelines, which requires inclusion of all income from whatever source derived, and it fails to apply the guidelines across the full range.
Hey, Ms. Dudy,
Yes.
the judge made findings of fact, and you allude in your brief that there were errors in some of these findings of fact. As I'm sure you know from doing all your research, if there's anything in the record that supports the finding by the judge, we're bound to accept it. So with that caveat, can you tell us what specific findings of fact do you think were clear error made by the judge?
Sure, Your Honor. The findings 37, 43, and 60 are the most.
Hold on, that was fast.
Oh, sorry.
37,
37, 43, and 60 are the findings that have the most significance. The medical risk, 37 states that no medical risk was present. That is contradicted by medical records. These findings are directly contradicted by not only medical records, but also testimony.
And just one thing that I had a little bit of trouble with in both of your briefs is identifying whether materials that you had included to us were actually part of the trial record. So when you talk about the medical records, let me ask a question that actually I can understand. Did you submit anything to us that was not in front of the trial judge in the form of evidence during the trial?
So the only thing I submitted, which I put as a separate addendum, was regarding the attendance piece, which I was not able to speak because my time was up. Everything else, it's my understanding in that brief, was present at trial and admitted, as far as the photographs of Blake's swollen face,
Great.
the medical
Thank you.
records as well.
So it's, this is impressive advocacy. Medical risk, attendance report, and what was the third finding?
So the findings that I was unilateral, I also strongly disagree with. The findings that are inconsistent with the record, there's my testimony as well as emails and other admitted. I also disagree that the communication was effective. That is findings 60 through 61. There is evidence of hostility and unilateral decisions to expose Blake to his allergens without letting me or his doctors know.
Okay, so I looked back, thank you for pointing out the specific findings.
Sure.
So you mentioned finding 37.
Yes.
And that is the one where the judge made a finding that there was no credible evidence that the child was at risk with father.
Sure.
I know you disagree with that, but how do we find that that was clear error when father did testify that when he goes out, he tells the manager, the server, what the allergies are?
Great question. So also in the testimony, father speaks to the fact that he had, and there's actually a spreadsheet of when I discovered 2 years after the exposures, the intentional exposures of Blake's allergens had started, that he had been feeding him his allergens. And on every anaphylaxis plan, we have every document that we've provided to the schools, the number one way to keep Blake safe is strict avoidance of those allergens. So, and additionally, Your Honors, we had an emergency trial because there was an anaphylaxis event when father purchased the cashew bar, the first visit after the findings, or not the findings, but the judgment was issued. We went to an emergency order that was in front of the judge the same day that she issued findings later in the day, and still those were her findings. Regarding the medical risk as well, that is clearly not supported in the record, which includes photographs of the child's face. He had severe swelling, and I was not aware of it until the child contacted me the next morning with what, to me, appeared very significant symptoms, along with other symptoms that had happened that I was not privy to, other than father letting me know that there was a stomach bug going through their house and he would not be attending school. At which point I reached out to son to say, hey, bud, I heard it was his birthday. So I said, I heard you're not feeling great. And he said, Mom, my face is all swollen, and FaceTimed me at that point. And that was very concerning, especially knowing what had transpired the night before. So this was an incident that I was only finding out about the next morning from child.
Can I jump in here for a moment? And I mean, I was so impressed in reading both submissions, and frankly, whether you agree or disagree with what the judge wrote, with so many positive qualities of both of the people that appear in this court. And what a lucky child to have both of you in their life. It doesn't happen. We don't see that very often. And so it's a little frustrating to me that despite paths going different ways for both of you, you made it work for so long, so beautifully. And I know you disagree with finding of fact number 43, which talks about after COVID and unilateral decisions that affected kind of the parenting. But there's something to be said here, and I hope each of you recognizes, and we'll make the decision, it's what we get paid to do, it's what we love to do, that each of you has for the other parent of the child that you love completely. An incredible person. And it just seems to me, and maybe there isn't a question mark at the end, that it worked so well for so long, but we're here now. What is it that you want this court to do?
I would ask that, I will speak to one piece, which is that the custody piece that I was speaking to, we have put an agreement in place, an allergy, actually that's an important thing to mention. The anaphylaxis event that occurred before findings were issued, where father had exposed Blake, bought him a cashew bar right after, obviously was very concerning to me, but we did, the court later approved a medical safety agreement requiring strict emergency protocols, which interestingly is inconsistent with the finding that there is no need for, or that there is no risk in place. But I now, and have always wanted to have father and I have rights for Blake. I just needed to protect my son, and that was what was most important. So I feel comfortable with the custody piece as is, and I will certainly, if something arises, have no problem coming back to this process. I hope we don't need to, but I feel comfortable with custody as it is. What I would like to have taken or readdressed is that I would like the vacated amended judgment and remand for calculation of child support, and then also corrected findings based on the record. There was, it was substantially limited due to time constraints, and most of my exhibits were contested, and so they weren't able to get in because we did not have the time, but I think the record stands for itself, and hopefully that's all I would ask.
Justice Walsh asked an excellent question, and you gave a great answer, that you're comfortable with the custody piece. The findings which you pointed to today that you think were error, they sort of all go to the custody piece. They don't go to the child support amounts. So I guess, and I know you don't have a lot of time left, in the 4 minutes you have left, can you talk about what was wrong with the child support amount?
Sure, that's a great question. So the findings for that were 82 through 90. Income findings, the bonus was minimalized. Father works for a close friend and historically has had a large percentage of his income in in-kind and perks, including real estate at discounted rates and things along those lines. So limiting the safeguards we put in place in our agreement in 2012, which showed full disclosure of all forms of income, limits not only the structure of the income as far as limiting it to W-2, but even if that's the case, the disclosures were taken away, and the tier system that was set up does not provide for even the W-2 income to be provided for full range. So base ends at one point, and then there's a substantial amount of income before any child support is due on tier 1, even if you just look at the W-2 income. So excluding things such as a car allowance that has consistently been in place, currently it's $1,600, I think it was around that even in 2012. Those are regular and consistent payments to father that reduce his income, and I
It
do
increases income, I think.
recent income and
I see what you mean. They're
historically,
being
it's-
moved from money
right,
to
it's
another
been-
form.
Yes, exactly. So it should be considered, and certainly, I also disagree with the finding that this order is sufficient for the child. I've had to liquidate retirement accounts and also the finding that our households are similar in lifestyle. That is also not in the record, I believe. But I'm not asking the court to reweigh the evidence, only correct the findings inconsistent with the record, and then remand child support calculations to include all forms of income available to the father per the guidelines, Section I.
Anything else? You have a minute and 38 seconds, but feel free, if you have nothing further, you can submit your argument on the brief, but it's your time.
I think that's all. Thank you, Your Honors.
Thank you very much. And I'm not sure if I mispronounced your last name.
That's okay.
No, it's not. Is it Scribner?
Scribner.
Well, then I take back my apology. Whenever you're ready, Mr. Scribner.
Good morning. May it please the court. My name is John Scribner, and I'm the appellee. I'd like to make a few arguments in support of this court affirming the judgment. First, under Prenovo versus Prenovo, the appellant bears the burden of showing clear error or abuse of discretion. The record in this case does not allow the appellant to do either. Next, the trial judge heard the witnesses and made credibility determinations, reviewed the evidence, and applied the best interest standard to joint legal custody under Mason versus Coleman, as well as Rolled versus Rolled. The
Do
trial
you mind picking up your
Sorry.
thing? Yeah, thank you. It's hard to hear you, and we're all old. Well, I'll speak for myself. I'm old.
The trial judge also followed the child support guidelines within the court's discretion under Smith versus Smith. Every finding is supported by the record, and this judgment is entitled to deference. Therefore, I'm asking this court to affirm the judgment. Thank you.
Did the judge factor in your bonuses when the judge calculated your income?
Yes, Your Honor. The base tier includes my base salary plus my yearly car allowance. And then there's 2 tiers above that, which includes discretionary bonus income that I may receive that given year.
But your contributions went down, if I read it correctly. Even though your income seemed to go up, the math has never been my strong subject, but there seemed to be some inequity here, at least at first blush. And I understand, and I agree with your position of, there was an experienced judge who heard evidence and credited certain testimony, et cetera. But numbers are numbers. And I'm looking at these numbers, and I just wonder how that fits within the guidelines, because am I wrong in that your payments went down?
The base tier went down, but prior to this judgment, there were no tiers above that to capture some of the bonus income that I'm receiving. So the $250,900 presumptive minimum income was my base salary plus my yearly car allowance plus the $80,000 that the judge attributed to the appellant. And there's 2 tiers above that.
Right.
From
In different percentages,
right. So
right?
between the $250,900 up to the $400,000 cap is 1 tier, and then the second tier above that is above $400,000.
No, I understand what the judge did. I just question, does it fit with?
I think it fits the circumstances, given my income fluctuates drastically above my base salary, which that income is not guaranteed year to year, which is why the judge chose to put those tiers in place to account for that, if and when it takes place.
Is there anything else that you'd like to say? We can rest in your brief, or you still have 11?
No, I could rest here. Okay. There's no further questions.
No further questions. The case is submitted. Thank you both.
Thank you.
Excellent argument. At this point, we'll take a mid-morning break. We'll be back in approximately 10 minutes.
Court, all rise.
right, good morning still. We are on to docket 25P0571. You're going to have to help me with is it Bassicchis versus Von Thaden?
Yes.
Okay,
Yes.
very well. Attorney Lawless.
Attorney Farber.
Excuse me,
as the
Attorney
appellant.
Farber. I was doing well until then, so Attorney Farber.
All right. So with that said, I just want to notify the panel that I do wear hearing aids, and I'm going through a time trying to get them to work right. And so anyway, the court officer has left me with the other things, but I'm going to go with it. And so anyway, my name is Peter Farber, and I represent the four, I should say, and the first name is Bassicchis. That's how he pronounces his name. I want to begin by first pointing out a mistake that I made in my reply brief, and I'd love to be able to say it's a typo, but it started up here, so it's not a typo. But it's on page 14 of the reply brief, and I cite Mass Rules Civil Procedure 52A, actually, and I intended to say Rule 55. And because the discussion that follows are the cases that I cite in the opening brief at page 33, all of which stand by the proposition that, and I quote, where a defendant defaults, the factual allegations in the complaint as to liability are deemed to be admitted by the defendant and treated as if they were true. And that is
I'm glad you led with that, counsel, because I have a hypothetical for you. Does that mean, under your analysis, that if two sides of the V, on one side of the V you have 100 defendants, you sue 100 defendants. If one of those defendants defaults, 99 of them answer, but if one defaults, that all of the allegations as to all of the 99 other defendants are true?
No, that's not
That's
at all
what they
my
say,
position.
right?
My position, actually, you've hit on a very good point.
I try every now and then to do that.
My position is that it's deemed to be admitted by the transferor, William Von Thaden, and he is the primary defendant in this case. Ms. Von Thaden comes up, she certainly, as I said in my briefs, she actively participated in this whole thing. But as to her liability, that comes later. That's in the second part of a 109A analysis or any kind of a reach and apply analysis. But first, we have to establish the debt, the underlying debt. And we do that only through William Von Thaden. He's the defendant. He was the only one that was defaulted. These allegations in the complaint, or what I call it's really the amended complaint, are deemed to be admitted by him. But he's the transferor, and that's where our attention is centered. Interestingly, the judge of the Superior Court did not even address that issue.
But even though they're admitted, let's say I agree with that premise, that they're agreed as to Von Thaden. In this case, that would mean it also would err to the wife, wouldn't it? Because you're saying that he's agreeing that there was a fraudulent conveyance because he defaulted, and that would affect the wife, wouldn't it, in this case?
Hey, you end up in a rowboat, and there are just two of you, and whether you get to shore or whether you die at sea, yes, sometimes we're connected in life.
Hypothetical, if one person defaults and somehow those facts affect the 99 other people, too bad for those 99 people.
Your Honor, I think you're stretching it too far.
Darn right I am, but that's the premise you're suggesting.
I say this, that Mr. Von Thaden, William Von Thaden, admitted that his intent was to convey the property to his spouse through this collusive divorce, and so as to hinder, delay, defraud his creditors. He admitted that. He admitted a lot of other facts that are in the amended complaint. For instance, I think it's on page, I'm not sure exactly, at some point I because I looked at the records as I was preparing for this trial for years, and the money was not dissipated. What the records show is that he was using money from his new jobs to pay old bills, and it just got beyond his control. But during that 2.5-year period between 2014 and the divorce in 2000, we'll call it 16, 2.5 years, he took money out of the LPL financial, the retirement accounts, and he didn't waste it. I mean, maybe he had a drink at a bar and it picked up the bill, but the money went into his business account. $334,000 then was removed, withdrawn from his business account, and deposited in what I call the family account, all right, to pay the mortgages, the real estate taxes, the utilities, all the expenses for raising the children, buying them Jeeps and all this other thing. So he didn't waste it. Again, the Superior Court judge did not address that at this much, not at all. So this whole dissipation argument that they used in the probate court should have been looked at by the judge of the Superior Court, because he based his decision entirely.
Can I ask you, so I understand your position about if an individual defaults, then everything's admitted. But here, we have specific findings, right, in the divorce proceedings. I mean, like an actual hearing in which parties had an opportunity to be heard and a decision based upon the merits by the judge. And so now you're saying that should have been given no weight, some weight? What do we do with that?
Which judge? The probate and family court
Yeah.
judge? So Judge Gandora, all right, he's retired,
Right.
wonderful man. He was given a consent judgment. And there's a lot of law that says really a judge doesn't interfere. If Party A and Party B, the contestants, agree on a certain disposition is not offensive to the law, then he signs his name. That's what happened here. We all know that's what happened.
Okay, but, well, maybe we all don't know it, thankfully. But what I want to ask, though, is what's your position as to what the Superior Court judge ought to do with that?
What should he have done with that?
Yeah.
See, I had no objection when the findings came in as evidence, as a uncontested exhibit in Superior Court, because indeed that's a matter of public record. Okay, that came in. I didn't object to any of that. The question is what follows from that, and I think that is what your question is addressed to. My people were not obviously parties to the divorce. They had no opportunity to bring in evidence of the bank records to show there was no dissipation. They had no opportunity to cross-examine anybody, to ask even the simplest question of Mr. or Mrs. Von Thaden. They didn't have that opportunity. In my view, big X. When it gets to the next court, my people cannot be bound by those findings. That's my position.
So what does it mean when you say it came in and the judge had a right to have it come into evidence? Once it's in evidence, he can consider it for something, right? Or else why is it in evidence?
What brings your comment to mind in my mind is the hearsay rule. A statement can come into evidence to prove, but if it's going to be used for the proof of something, and it's hearsay, then it cannot be used for that purpose.
Then it shouldn't have come into evidence because it's being admitted for the truth. But in this case, you agree that the findings of fact of the probate court judge were admissible, okay? So let's assume for a second that at the Superior Court trial, your clients put on a plethora of evidence that was different than what the findings of fact were at the lower level, okay?
Okay.
the judge has two pieces of evidence, what your client admitted and the findings of fact. He had the discretion to agree with the findings of fact, doesn't he? Or else why is it in evidence?
Because then it is so offensive to the rule that, which I've stated quite, I think, several times in each of my briefs, that those where my people were not parties to that case, the facts, if you want to call them facts, cannot be held against them. They didn't
Counsel,
have any opportunity.
I'm not disagreeing with you that maybe those findings of fact should have been admitted.
Should not have been
I'm
admitted.
not. But they were without objection. So once they're in evidence without objection, and I believe there's plenty of case law, when something comes into evidence, a judge can consider it for its full evidentiary value, which means he could have accepted what was in that document.
Okay. I objected to at one point, the judge and I had a colloquy, and I said to him something to the effect, I don't think it should come into evidence, much along the reason that you're saying. And he said, well, why? On what basis? Because he's thinking, oh, a judge's finding. I mean, what am I going to do here? And I said, because it's hearsay. Because it's not evidence coming in this case, in this courtroom, and I didn't have any opportunity to cross-examine or contest it or anything.
So you preserved an objection
So
to
I
having
think
the
I
findings and
preserved that
evidence.
objection. Did I think I was going to win on that objection? No. I thought he was going to let everything in. And he did. And he didn't even, when you look
Is
at
that
the-
somewhere in the record that you objected, counsel? Because I didn't see
It would
that
be
in your brief that you
it would be in-
objected.
It would be in the transcript of well, there were only 2 days of trial, so it would
Right.
have been the first day of trial
Okay.
when we were talking about admitting evidence.
Can I distract you for just a moment to talk about something I'm trying to puzzle through? And I think there's an easy answer, but I just don't know what it is. Part of the divorce proceedings that you're contesting, obviously, the proceedings, is the statement that $183,000 shall be held in escrow by the Barnstable County Sheriff. Two questions. One, was that done?
Oh, was it money taken? Yes.
Yes. And two, do your clients contend that that amount was inadequate to satisfy the debt to them?
Yes.
By how much?
Well, you could compare it to
I mean,
of course,
roughly.
the judgments came much later. But, for instance, in Bassicchis, the underlying debt was $55,000 or
Okay.
whatever, and the judge that awarded the attachment early in the case I think it was $55,000.
Okay,
In
so
the end, when you added interest and
Okay, so-
93A damages, it got up to $211,000.
okay.
So, no.
So by operation of time and multiplication of damages, it became not enough.
I'm sorry, say it one
So by operation of time, which allowed for interest, and then multiplication of damages. So it might have been enough to cover the claims, but not the judgment.
Right. And
Okay.
just so we're also clear, I represented other parties who also got attachments. One was a painter, and luckily, his attachment was almost entirely what his bill was. So at the closing in July of 2017, the deputy sheriff handed me what totally satisfied the painter. So there were it was 183, I don't think was the final number.
Okay.
But
Thank you.
anyway, what this case, I think, is all about is what impact should that probate and family court decision have on the Superior Court? That's really what it is. Our position is that it should have no effect, other than just to see what happened in that case.
Let's assume you're correct on that. Doesn't there have to be evidence that there was a specific agreement between the husband and wife about a fraudulent conveyance?
About the what?
About your alleged fraudulent conveyance? There has to be an agreement, doesn't there?
Well, Judge, like what you see many in the records is they never had a conversation, right?
Right.
So I can see the wife's attorney saying, don't talk to Bill. because
But
I want to
there's
be...
no evidence of that, counsel. You're certainly imagining something that might be helpful, but the judge made a finding that there was no specific agreement. Forget about a conversation. There was no agreement between husband and wife that there was any fraudulent conveyance. And in order for there to be a fraudulent conveyance between the two, doesn't there have to be an agreement between the two?
Absolutely not. I disagree with that. We're talking about the Superior Court judge now,
Yep.
okay? Because for the probate and family court judge, he just accepted what was given to him. I mean, my brother might contest that, but the Superior Court judge I believe, has to do a deeper analysis. But it's not going in the direction you're suggesting, Your Honor. I think the analysis first under 109A 5A1 was their intent. That's the first question, was their intent. I don't need to get together with anybody in this courtroom and decide whether we're going to go to a certain place for lunch. We could just walk to that place because we're talking and we go there. You don't need a specific conversation. What you need is the actions that are inferential and they show what happened. And that's clearly set forth, in my opinion. This judge in the Superior Court never, am I over my time?
You are over your time, so if you could, unless there are any other questions to the
Okay.
panel, just
Anyway,
summarize here.
They were very careful not to have any explicit conversations or agreements, but certainly when you look at the record, you can see what happened, what was done. And that was certainly,
Okay, and so I think we'll have to leave it
could go on
and rest
forever.
on your brief.
Thank you very much.
Okay.
Please the court.
Attorney Wallace, thank you.
Attorney Robert C. Lawless on behalf of Kim Von Thaden. She is the defendant in this action. And I just want to say that, may it please the court. The issues that we see brought forth in this appeal truly are frivolous because my brother, and throughout his oral argument and throughout his brief, cite facts that aren't in the record. They just imagine. He just spent a minute talking about bank records where it shows that it went into the husband's bank records to pay for the local mortgage. That was not offered into evidence in the Superior Court. That was not part of the record down below. Incredibly important in this case is there was a divorce trial. There were 21 exhibits offered in the course of that trial. The judge made extensive findings of fact that are all in the record for you to see. Secondly, those findings of fact and the transcript and all of those exhibits were entered into evidence in the Superior Court.
Should they have been?
Absolutely. First of all, and I direct you to Volume 1, page 70, 71, 72, 73. That's the exhibit list. This was a typed up exhibit list. It was done before the trial by agreement with counsel.
So when you say they should have been admitted, you're saying because there was no objection?
Well, there was no objection. Secondly, a transcript of a trial is testimony, just like a deposition. It would be admissible.
Well, except the other side had absolutely no opportunity to cross-examine in that other trial. Wasn't even a party in that other trial.
Correct. And had full, ample opportunity to cross-examine Kim Von Thaden when she testified at this trial. Because, and this is the key component, the Superior Court trial was a replica of the divorce trial. All the evidence that was offered at the divorce trial was again offered to the Superior Court judge, element by element by element. He saw all of the exhibits from down below. He could make the same conclusions as he did.
That might all be true. But if a Superior Court judge, without objection, admits the findings of fact of another court, is he, under your argument, bound to accept those findings of fact?
Not bound, Judge.
Okay.
I took them as persuasive and indicative of why this was not a fraudulent conveyance.
Okay.
Because their argument all along, and I gave you a citation to Bassicchis versus Flores. Attorney Flores was a divorce trial. Mr. Farber's clients, through Mr. Farber, sued him and took the case all the way to the SJC. And there the argument was, well, there was this tremendous amount of fraud. There was misrepresentations made to the trial court judge. Of course, the SJC had to accept those as facts because it was dismissed on a 12b-6. I get it. This trial in the Superior Court was Mr. Farber's opportunity to bring in all that evidence. 0 witnesses testified from him. He rested after he opened. He had ample opportunity to offer these alleged documents that showed things.
Well, but Mr. von Thaden defaulted and never answered the complaint. So one can see how it could have been a strategic decision to rely on the law that says that a defaulting party is found to have admitted the allegations.
The defaulting party, but not my client. At every single step of this proceeding, including the default judgments, I came to court on behalf of my client to argue strenuously that really they should hold off that decision until we have our trial. But the judge made their findings,
So let's talk about that. The facts are accepted as true to the defaulting party. So if the complaint asserts that Mr. von Thaden fraudulently conveyed property, and that's accepted as true as to Mr. von Thaden,
correct.
doesn't that automatically inure to your client because she's the one that received the benefit of those fraudulent conveyances?
But there was no fraudulent conveyance,
Well, but
number one.
it's
But number
accepted
two,
as true. You just said it's accepted as true.
accepted as true as to Mr., but not as to my client.
So how can there be a fraudulent conveyance as to one person who's transferring the property to person 2 and it not inure to person 2?
Because he defaulted. Because he defaulted. There was 0 evidence offered of a fraudulent conveyance. In fact, the Superior Court judge, after listening to the witnesses, found that there was no fraudulent conveyance. It's very important that the concept of fraudulent conveyance included the notion of equivalent value. The equivalent value standard is required. In other words, if the day before their divorce, all the property or any person's divorce, all property is conveyed to the other person. All your $1 million worth of assets are conveyed to the other party for no exchange whatsoever. There's certainly an implication that there's a fraudulent conveyance. But here, Judge Scandor, after hearing all the testimony, found that the husband had somewhere really in the factor of $900,000 worth of assets that he dissipated them. He used that money in ways that were offered during the course of the trials. Both trials, there was evidence of what Mr. von Thaden did to drain the accounts. And Mr. Farber, in his brief, argues, well, it's not there. I differ with him. And I set it forth in my brief, where the LDL accounts, Mr. von Thaden, fraudulently signed my client's signature to papers and took the money. He took the money, and the judge held him responsible for that. And under both the Kittredge case and the second case that I cite on this issue, talk about the fact that this was an appropriate finding of dissipation.
We've been talking as if Section 5A covers the division of assets in a divorce. So Section 5A says, this is Chapter 109, obviously, a transfer made or obligation incurred by a debtor is fraudulent, etc. Do you have any legal authority as to whether or not the division of marital assets pursuant to a divorce is a transfer or obligation under this law?
I have found that there are other bankruptcy court cases I haven't cited them here, where they have found fraudulent conveyance. In many
In a divorce.
in a divorce where there's a sham divorce. And that's the key. There was no evidence that this was a sham divorce. On the contrary, my client remarried after the divorce. She was left high and dry. Her 3 children, she had the college funds dissipated. She was held responsible to basically supplement.
But, I mean, you're talking about differentiating if it's a sham divorce. I guess my question is, if a husband, the day before the separation, says, hey, I owe $1 million to X corporation, rather than X corporation, I really screwed you during the marriage, I'm going to give it all to you. And sort of does that so the corporation doesn't get paid. Isn't that a fraudulent conveyance, even if the wife's owed that money?
Well, I would say it's not if she's owed the money.
But isn't it
because
the
there has to be
intent to
equivalent.
defraud? Isn't the fraudulent conveyance looking at the intent to defraud the person that's owed?
But critical to that is that equivalent value. Is there an equivalent value?
Okay.
And here, the judge found a very specific sum that he incorporated in his chart that was attached to his findings on page 70 of his findings, where he said that the husband had $996,000 worth of assets, and she got $810,000. And that, the argument throughout Mr. Farber's brief that, that Mr. received nothing is not true, because there was $183,000. In fact, there's a footnote in the findings that the Superior Court judge articulates specifically where those monies went. So overall, when I come back to this, when you assess this, there was an equivalent value. And the equivalent value is what Mr. Von Thaden received. And the probate court judge went through that in detail. The Superior Court judge heard all the same evidence and again came to the same conclusion.
Do you recall at the Superior Court trial the opposition actually specifically objecting to the findings being admitted into evidence?
I don't, and I first rely upon the fact that it's right in the schedule. Okay. It was typewritten before the trial.
Okay.
And there we also had two forms of the trial transcript. One was sort of a mini script, and then the judge said, can you give me a better copy? So twice, the transcript of what happened down below was offered into evidence. And this judge had the basis to make the same findings that the probate and family court judge made.
I mean, this is an interesting issue to the extent that, on one hand, whether by agreement or whether independently kind of admissible, your argument is that the judge was acted appropriately in considering the divorce proceedings, right? Number one. And by the way, to the best of your knowledge, no objection that this came in. But on the other hand, if a default judgment is to have any teeth, I get what you're saying to Mr. Von Thaden, the actions of the fraudulent conveyance, not who it landed to, but the actions by defaulting, that seems to me that that's cemented in that finding of fact. While he can't get out of it and contest it and say, no, I didn't fraudulently convey this money, et cetera, because he didn't show up, he forfeited that right. But it seems to me now you get your cake and eat it too, because now you're claiming, well, as to Mrs. Von Thaden, even though she's the recipient, if we have this cemented in that Mr. Von Thaden fraudulently conveyed this money in order to avoid paying his obligations, how is that kind of fundamentally fair?
Well,
that now we can have a burden on the plaintiff to say, okay, now we've got to prove it again as to Mrs. Von Thaden. We got to, even though it's stuck here, I understand why Attorney Farber got up and said, no further questions, right? No evidence, because I've got this piece on the default cemented in here.
But the default is only as to that party.
The
Because the
effects-
proposition that you're suggesting is just what Justice D'Angelo suggested earlier, that then 99 other defendants would get stuck. And that's not fair.
So hypotheticals are great until they aren't,
Well,
right? And so
I'm
the
happy-
problem with this is that in this real-life case, if there was wrongful doing, it was by Mr. von Thaden, right? And taking money that was otherwise obligated here and converting it and moving it over here to hide it, right? Whether or not owed or not. So the problem with the hypothetical is that all of the behavior that's alleged is by the very person who the judgment, the facts are admitted.
And all of that that is quote-unquote admitted by Mr. is denied by Mrs. at the trial, where there are then findings of fact by the judge. And where is the reasonably equivalent value in your hypothetical?
Is by the fact that Mr. has now a default judgment, and it's admitted against him. So when Mrs. say, Mr. von Thaden didn't steal this money and give it to me, it's already admitted.
But the reasonably equivalent value standard that is required in order to prove fraudulent conveyance says that he did not have a reasonable equivalent value. And that was established at both the divorce trial and again in the Superior Court.
I don't think you're right about that. I mean, as I read the statute, reasonably equivalent value is 5A2, which follows an or clause. So as I read the statute, which granted one can't always do and then rely on it, but 5A says a transfer made or obligation incurred by a debtor is fraudulent as to a creditor, lots of words, if the debtor made the transfer or incurred the obligation, (1) with actual intent to hinder, delay, or defraud any creditor of the debtor. And then it says or. So do you disagree with me that as a matter of statutory interpretation, one could prove a violation of Section 5A by proving only one and never getting to two?
Yes. In fact, if you take a look at the case I cite, In Re Blast Fitness Group, it's a bankruptcy court, specifically talks about what the elements are on both 5A and 6A. And in both cases, the holding was, and it's supported by the case law, I think also in TriStar Technologies, that the requirement is reasonably equivalent value as an element that they must prove.
Even though it says or. So this is one of those situations where you have to be a lawyer and know that or means and?
Well, I think it's one of these situations where it's required that, in other words, they must prove that he did not, because in other words, if someone sells something and they sell it for its value, then there is no fraudulent conveyance.
No, I understand the reasoning. I'm just asking about the statute, which is often not anywhere close to reasoning, because,
Right.
that's
And
how the law
I'm
is.
looking at, again at the case law.
Okay.
That requires that as an element. And I do ask that this court take a look at, and I know that everybody throws in at the end of their brief, to assess attorney's fees, because again, if we look at my first argument, this brief was riddled with allegations that just did not exist, and then forced not only me, but this court to have to go through the machinations of establishing what was properly before the court and not. In the case that I cite that supports this, of
I think you'll
Avery
have
versus...
to rest on your brief for the citations.
Thank you.
Thank you. The matter is submitted.
Thank you.
Well done by both. All right, next up is docket 25P0872, Wong versus LEUNG. And Attorney Cooperstein?
Morning, Your Honors. Peter Cooperstein on behalf of the appellant Edward Long. I'd like to first address the property that's referred to as Damrell Street, where the property was ordered to be sold. That actually has been stayed by the lower court pending the appeal. When you divide the marital estate, the judgment has to be apparent and flow rationally from the findings. Here there was an abuse of discretion, as the order to sell Damrell Street was not apparent, nor does it flow rationally from the findings.
Well, we can perhaps argue about the flow, but it seems to jump off the page as far as apparent. There was a $12 million discrepancy. Wasn't there a $6 million discrepancy between the high and low
believe so.
number?
It was a high amount.
So, and it seemed as if, at least on several occasions, the judge forecasted, I know of a way to kind of figure out what this property value is. And there's a mechanism to do so. And there's a great gap here. So when reading the transcript, it wasn't hidden. It certainly seemed to be apparent when reading what was going on here. Do you disagree?
I do, because
Okay.
the judge says, I don't find either appraiser credible, I'm going to sell it. But then he makes a finding what the fair market value of Damrell Street is, which is about $13 million, with the mortgage of about $6 million. And then on paragraph 11 of the judgment, when it talks about 668 Enterprise LLC, which owns Damrell Street, he writes that it's to be bought out or sold. So you have two.
Well, 668 will cease to exist, right? The only holding 668 has is Damrell, right?
Right, but it says, as I said,
Bought out
it
or
provides
sold, right,
Damrell
right,
to buy out or sold. And then when you look at the findings, it talks about wife's estate, and it talks about Damrell, and it says buyout due from Damrell Street, meaning that husband's to buy out her 1/2 interest in Damrell Street, not to sell it. And then it's consistent with each part, with the proposed judgments, where husband proposed that he retain Damrell Street, and wife proposed that husband has the first option of buying out wife's interest in Damrell Street.
Well, isn't that contingent upon them or there being some agreement as to what the fair market value?
I would agree with that, yes.
Okay, and that,
But
understood.
yeah. And when you interpret, I believe this is an ambiguous judgment because you have two different provisions that conflict with each other. In interpreting ambiguous judgment, you need to search through the entire record for clues as to what the parties in the court intended. And I believe when you look at the entire record, the judgment, the findings, the post-trial submissions, husband should have the option of first buying out wife's interest based on what the court found to be the fair market value. And I would agree with you, Your Honor, that the first is why he orders Damrell to be sold makes sense. But then he makes a finding that it was the value, and he cites to husband's appraiser, Mr. Fitzgerald, I believe it was. In his judgment, he cites to the record, the transcript on that. I also, next I would like to discuss the restaurant, which we refer to as Fuji, and the bus company, which is Lucky River.
So husband wanted to keep Fuji, right?
Initially, his first proposed judgment, which, I mean, the proposed judgment had him retaining everything, pretty much. So.
And so I guess I'm confused because, first of all, in some instances, he got what he asked for, which was the right to keep Fuji and pay out half of what it was an agreed upon assessed value of 2.3, right? And now you're looking to say, well, husband can sell Fuji to pay, right? But why would you be at all, I guess, help me understand, why couldn't Fuji be sold anyhow? I mean, what's clear is that wife gets 1.15 according to this order. If husband keeps it or the restaurant or doesn't keep the restaurant, I was unclear as your ask. What is it?
I'm asking that the Fuji be sold and the proceeds divided equally. And so the value of Fuji that they stipulated to was based on the value as of 12/31/2022. After the husband got the judgment, he realized that based on what he's getting and what she's getting, it made more sense to sell Fuji. And I mentioned when it was valued because by the time we got the judgment, 2025, Fuji, as he testified that it was recently not doing well, that's what happened. Fuji,
So if it was doing really well and it was worth 10 million, your position would be then wife is entitled to 5, I'm going to sell it, and wife is, under the terms of this language, wife is entitled to 5 and I'm entitled to 5?
I understand that the value went up. But he did, you know, in his motion to amend, after the judgment, he did request that Fuji be sold. And wife proposed that Fuji be sold. And
Is
so,
there anything even there anymore? The restaurant closed.
close, yeah.
Right, so is this a live issue?
So there was a judgment of contempt. Well, I guess, yes, because unless the judgment gets amended, he's on the hook for the, the 1.15 million. But it has closed, and under the judgment of contempt that has been issued well after the judgment of divorce, the judge ordered Fuji to be sold to comply with the judgment. Now, I'm not sure what that actually means, to comply with the judgment, but that's the status, is that it's closed, and I don't think talking to my client, there's nothing there.
Okay. Can we turn to Lucky River?
Sure.
Thank you. So, net proceeds. You wanted, at least the judge, to go back and amend and clarify whether the debts incurred and signed by husband
Yeah,
would be taken off the sale.
correct.
Is that it?
Well, the issue is what happens if Lucky River sells
And there's a
and
debt that's
there's
still
not
left
enough.
over. That's exactly
The proceeds
what's
don't
left.
cover the debt.
Right?
And it was clear that the judge intended for an equal division, but if husband's responsible for all the loans or even half the loans because there's not enough sale proceeds, that 50-50 division, it's not going to happen. It's going to be significantly less in favor of the wife.
So help me understand this, because it seems as if in other valuations, husband knew well when there was an entity that had debt, that the value placed upon the what it's worth today included the debt. So there was an instance with another restaurant in which there was a significant amount of debt, which reduced kind of what's this place worth now? It's because I got so much debt, and it would have been this, but now it's much smaller because we're so heavy in debt. And so here, it appeared that this already was considered in the appraised value of $200,000 for an entity that received loans upwards of $1.563 thousand, $1,500,000 plus more, had 3 additional buses that were purchased, et cetera, et cetera. So one, I question of, wasn't that already considered in the appraisals? And 2, it just says net proceeds. It doesn't say anything about debt. In fact, there's language in the agreements that say personal liabilities are people's personal liabilities. And this was signed just by husband, right? The loans.
Yeah, well, personally guaranteed, yes. So if you use the value of $200,000, which is after the debts and loans, et cetera,
Right.
if husband was able to buy her out, pay her the $100,000, which is half the value of it, then he would be responsible for all the loans because that's the value.
Right.
But Lucky River was ordered to be sold. So what I'm saying is let's say it sells for less than the 200,000, right? Or enough to cover the loan, whatever the value is, right?
Still in debt.
You're still in debt.
Right.
But there's nothing in the judgment that says that if the sale proceeds aren't sufficient, then each party is responsible for half the loans and liabilities.
Half the debt.
Right. And he asked that, for that to be a clearer definition in his motion to amend, and wife acknowledges that, says, well, yeah, of course it does. Well, but unless you have a judgment with an order, you can't be found in contempt, the court can't enforce it. So the court should have amended, I think. The court should just amend it and say, yeah, you're right. It should be after liabilities, et cetera, and to the extent that it's insufficient amount to cover the loans and liabilities, that should be divided 50-50 too. You're dividing the sale proceeds, you should divide the loans and liabilities equally as well. But otherwise, under the judgment, it says each party is responsible for their own liabilities, and a lot of the I think it was a COVID loan that he personally guaranteed of, like, that time, I think it was $1.9 million. So if that's not covered, the sale proceeds don't cover all of it, then he's stuck with that, and now you have a division of the assets that's no longer equal, right? It's now favoring the wife and less assets to the husband.
And that's one of the liabilities that you included in the chart on your brief on pages 22 and 23?
That's the chart, yeah. I don't know the exact numbers, but
Okay.
yes.
And so I guess my part of this is help me understand of, A, is this an abuse of discretion that the judge denied the motion for clarification or to amend? And secondly, is it properly before this court yet? Because all of this doesn't matter, right? If Lucky River sells for above what is owed and the parties divide equally whatever is left over. In my simple mathematician brain, which is very simple, is what's left over is the net proceeds. After all the debt is cleared and whatever's left in the pot, 50-50 is what I read that to be. So how is that properly before us right now when we don't even know what's going to happen? We don't know if there's a motion for contempt. We don't know.
So so you sell Lucky River, there's insufficient funds to pay off all the loans and liabilities, then he's stuck with it. So what's his redress? I guess a motion for relief from judgment. There wouldn't be I guess.
Is it an abuse of discretion standard on the denial of the motion to amend or clarify? Do you agree with that the standard is abuse of discretion?
On that, but also abuse of discretion in the judgment by not addressing it.
So, and secondly, how is that properly before us when it hasn't happened?
Well, the judgment still should say that. It should address what happens if there isn't insufficient funds. I mean, it has to divide as
That's
part
the
of
abuse
the...
of discretion.
Was that asked for by you at the lower court to address that issue of what happens if?
In the motion to amend, yes. And the other side acknowledges it in their opposition. But, as I said, it's not part of the judgment, so without the judgment, there's no order. So.
Well, the judgment says net, right? So if there's nothing, like half of nothing is nothing, and I know you have a further concern about your client's legal obligations under the various loans, but that doesn't seem like something that a judge would have to address in a judgment of divorce. It's his liabilities. I mean, I think, well, whatever.
Right, but if it's his liabilities, then it's not an equal division, right? Because let's say he each got $1 million of assets, but he ends up with $300,000 of debt. Now his assets are down to 700, and hers is still at $1 million. So it's not an equal division anymore.
But just help me understand this. When you submitted your appraisals, you agreed that Lucky River Transportation had a value of $200,000, and that included considering the debt.
Correct, correct. They stipulated to 200.
But it factored in the debt,
Right, and if he was able to buy her out at 100,000, that's, address all the debt, you're fine. But if it sells for less, to cover all the debt, and he's responsible. So that's the,
I understand.
yeah.
Thank
And
you.
I just want to say, I did withdraw the provisionally gun life insurance.
Appreciate it. Thank you.
Thank you.
Good morning, Your Honors, and may it please the court. Kevin Powers for the wife, Maria Wong, who is here in court today. Your Honors,
Could you start with the Lucky River?
yes, Your Honor.
Thank you.
Your Honor, the disposition of Lucky River and the disposition of all of the other assets are classic textbook exemplars of why the standard of review in legal determinations by at a bench trial where the disposition is controlled by 17 statutory factors is abuse of discretion. And as to Lucky River, Your Honor asked my brother about the phrase net proceeds. Your Honor, net proceeds can be negative. If the net proceeds, and we do not anticipate, to be clear, that the net proceeds will be negative because, as an initial proposition, as we argue in our brief, all of these business valuations, and in fact this is consistent with husband's own proposed asset division schedule filed in the trial court before the judgment. All of these business valuations, all of these equity in the business figures, already account for all of these business debts. That said, if God forbid we were mistaken, and as to market value or otherwise, and Lucky River were to sell, and there were some amount of debt left over, the net proceeds would be a negative number, and those net proceeds would be divided by the parties 50-50.
So if the net proceeds equal a negative number, $100,000, I'm just picking a number, then it's expected under this judgment that the wife would then have to pay husband $50,000 of that $100,000 debt? That doesn't sound like it's in the judgment. Am I not making, so if the net worth of the property is negative $100,000, where in the judgment does it say one party now has to pay the other party $50,000?
I don't know, Your Honor, that it's contemplated that one party would have to pay the other, but rather whatever entity is holding the debt, to whom the debt is owed, the parties between themselves would have to divide up whatever that arrearage is beyond the assets and valuation of the business, and between themselves pay that to whoever the creditor happens to be.
So what are you arguing about then here? Because you agree, right, that whether you can disagree whether the judge abused his discretion in not allowing the motion to amend, but it's not net profits, it's net proceeds. And if the proceeds are negative, it's split in half. If it's on the plus side, it's split in half, right? There's no confusion here.
None that I see, Your Honor.
On,
of course, again, our expectation, and this is sort of what's at play in terms of the valuation of virtually all of the assets at issue in this case. Husband painted at trial time and time again these apocalyptic scenarios of this business is going to sell and it's going to have to sell at a loss. This real estate property is valued so low, and he came in with abysmally low valuation figures. At the same time, The wife came in with much higher valuation figures, not only as to each business, but also, for example, as to Damrell Street, also as to Beach Street. Beach Street, of course, not being at issue in this appeal. And as to all of these, of course, it's wife's expectation that when each of these assets sell, whether the businesses or whether the real estate, the actual sales values in a fair market sale will ultimately be either something in the ballpark of her figures or vastly closer to her figures than to husband's figures.
But at the bottom line, either they both equally benefit or they both equally suffer if the market sends back a signal either higher or lower, right?
Yes, Your Honor.
So is that what's wrong with the chart that opposing counsel put on 22 and 23, that we don't know whether those liabilities are actually going to be liabilities until the times of the sales? I mean, that chart paints a very clear picture that that was not an equitable division of the properties.
Your Honor, what I would disagree with regard to my brother's chart is that he, number one, he allocates the COVID EIDL loans to husband personally rather than to the businesses, and at numerous instances, and if I may just for one moment. Here it is, at Record Appendix Volume 1, page 91, the judge found Lucky River received a COVID hardship EIDL loan paid by Lucky River. At Record Appendix Volume 2, page 118, husband's financial statement, he lists all of the COVID EIDL loans as, quote, paid by business, end quote. So this, again, this apocalyptic scenario of all of this debt is going to fall entirely upon husband's shoulders. Number one, this debt was never upon husband's shoulders in the first instance. This was business debt. It was taken by the business. It was paid by the business. Now, admittedly, husband did give a personal guarantee, but that's never been at play. It's always been business debt. It has always been paid by the business. In both instances, both the COVID EIDL as to Lucky River and the COVID EIDL as to Fuji Restaurant. And so we disagree entirely with my brother's chart, where he takes both of those COVID EIDL loans and he drops them entirely upon husband, as if, number one, those were not part of the value of the businesses themselves, and number two, as if, again, in a scenario that we have no expectation could possibly come to pass, but if there were any residual debt left after a fair market sale of Lucky River, again, the debt would be paid off 50-50 by the parties consistent with the judgment. Your Honors, I wanted to make a point of requesting leave to the extent that my brother stepped outside of the record and spoke about occurrences in the litigation, developments subsequent to the judgment from which this appeal arises. I ask the court for leave to not to get into that today, but to file within perhaps 48 hours, maybe 72 hours. I'll do my best to be as quick as possible. A 16L 22C2 letter by way of a response, so that I don't spend time getting into that today. I would greatly appreciate that.
Can you refresh my memory, I won't say our memory, as to what was outside the record? And if it's outside the record, I can tell you I don't think we'll consider it, but what was mentioned that was outside the record?
Your Honor, I believe that my brother spoke about various cross complaints for contempt and contempt hearings and that sort of thing, and all of which has occurred long after the filing of the notices of appeal, out of which this appeal happens to arise.
Well, Attorney Powers, obviously you can file whatever you wish and feel appropriate, but I think I could probably speak for the panel to say that most likely unnecessary, that we'll focus on the issues that were briefed by the parties.
Thank you very much, Your Honor. Your Honor, as a general overarching proposition in this case, what we have here are two parties who agreed on virtually nothing over the course of the litigation, and as the references, however much they should not factor into this appeal, to ongoing litigation, convey simply by the fact that that ongoing litigation exists, they still don't agree as to anything. Husband went in, and there was a colloquy that I believe I quote in the brief, where or at least cite to in the brief, where the trial judge asked husband's trial counsel, what is it that your client wants? He said, well, my client wants 100% to me and 0 to her. Okay, what counsel do you want? Well, I think it should work out to about 70 to him and about 30 to her. And the judge said, and this is virtually a quote, that's about 1 in 10,000 cases that you'll see that. And he went on to say, I'm not prejudging, and I'm not saying that this can't turn out to be that case, but that's about 1 in 10,000 cases. So what happened is, husband gambled on an all or nothing approach. And notwithstanding the judge's warnings, that Your Honors have mentioned during this oral argument with regard to, I believe the judge quoted Justice Bob Dylan in saying, you don't need a weatherman to tell which way the wind is blowing, and stated, there's an easy way to figure out what these assets are valued at. It's not going to require cutting a Gordian knot in any way, shape, or form. The judge warned the parties what he was contemplating doing. He was very, very explicit. Notwithstanding all of that, all the way to the end, it was all or nothing. And this is why we have the abuse of discretion standard of review. And if it were possible for litigants in cases such as this, or in any other kinds of cases, to litigate completely scorched earth, to demand 100% or, in a compromise, 70%, and reach the end of the road, see the judgment, find out exactly what the judge was thinking of doing and what the judge decided to do, and then at that point turn around and say, you know what, now that I realize that Your Honor was serious about selling some of these assets, hold on, let's change everything and let's second guess everything. That would incentivize litigants to take the scorched earth approach rather than being reasonable. It would incentivize parties to demand all or nothing, and then only after reaching a judgment after an all or nothing trial, finally try to look back and second guess everything. And that's what's going on here. That's why we have the abuse of discretion standard of review, and that's why, in the words of the SJC in footnote 27 to the LL case, the trial judge was within the bounds of reasonable alternatives, even if another judge on these facts might have ruled somewhat differently. The judge was within the bounds of reasonable alternatives. As to Damrell Street and as to Fuji. As to Damrell Street, the judgment, the dispositive order regarding Damrell Street is unambiguous. My brother cherry picks phrases from the findings, typo here, a line copied, I believe, from line 10 of either the judgment or the findings to line 11, and then the judge changed the name of the property but didn't take out the phrase buyout. At the end of the day, the judge is extremely explicit in stating that the only fair and equitable approach to this property is to sell it and divide the net proceeds after costs, commissions, taxes, and other expenses equally between the parties. We address my brother's other arguments on Damrell Street in the brief. As to Fuji Restaurant, we address that in the brief. And on the basis of those arguments and the arguments in our brief, we respectfully request that this court affirm the judgment below. Thank you, Your Honors.
Thank you both. The matter is submitted. All right, we're turning to 25P 1101, 10 High Street Restaurant versus Seth, Greenberg, and others. Attorney McLaughlin.
Thank you, Your Honor. Good afternoon, Your Honors. May it please the Court, Robert McLaughlin, Jr., on behalf of 10 High Street Restaurant, LLC, and Seth Greenberg, I'm going to address primarily two issues today. One is the sufficiency of the default notice, and argue that it's not sufficient, and the scope of the guarantee, and in particular with the scope of the guarantee, the effect of the guarantee after the termination of the lease. Let me start with what the lease says on the requirement of a default notice, and it is the obligations of the landlord to provide it in writing. It has to send it to 3 different places, including the attorney for the tenant, and it has to be sent by registered mail or overnight mail. Why is that important? It's important because although you can have some back and forth, and there is in this case, as far as money that's owed, you need to know as a tenant that now it's serious. Now they're going to take action against me, and I potentially will lose my rights that I have in the lease. And so your lawyer gets a copy. The lawyer has an opportunity to consider and look at what is alleged here. What does the motion judge find? And with regard to the grease trap, I'll start with. What does the motion judge find? He writes, and I quote from page 6 of his decision, the addendum, page 59, default notice asserted that High Street had failed to pay various amounts that it owed under the lease, including $21,000 some odd for grease trap cleanup costs. What does the notice actually say? The notice actually says with regard, it mentions rent, and then it says the reimbursement of insurance proceeds. And when we look at the lease, well, what's the obligation of the tenant with regard to reimbursement of insurance proceeds? And the answer is there is no obligation.
So as you know better than I, because I'm sure you've spent a lot more time with this record, though I feel that I've spent a lot of time with this record, insurance proceeds is the language that was used by the parties in discussing the reimbursement obligation for the backup in the grease trap and the resulting flooding and the remediation thereof. In a case where there was, and stop me if I go wrong, but I saw nothing in the record that showed that your clients were contesting their obligation for the grease trap remediation until after the notice of default was sent. I saw a substantial amount of communication during many months leading up to the sending of the notice of default in which your client referred to paying out of insurance proceeds, which I understand is because the restaurant had actually put the claim to its own insurer. We're entitled to consider that evidence, correct?
So the answer is it's in the record. You're entitled to consider the evidence. The answer, however, is there is no, if you look at the history of it, they're asking, they being Mr. Caroli is asking in many communications with Mr. Greenberg, you need to pay this, you need to pay this. There's no agreement ever to pay it. I would suggest by the lapse of time, the passage of time, that's the contesting nature that goes with it. Mr. Greenberg was trying to buy peace. He was trying to say, look, I'll give you
Well, no,
something.
I think he was trying to buy time, and that's not the same as objecting or contesting. Is there a communication that I just didn't see in the record in which Mr. Greenberg says, I don't owe this money?
So there is not a communication which he outright says, I don't owe it. What there is a series of communications where he never agrees that he owes it. And then it's followed by a communication which is fine. I'll put in a insurance claim with my insurance company, and I'll pay you whatever I get for the insurance. And again, when we get to a default notice, and then there's a cure right in this default notice, and we have to know what the amount of money is to bring me current in the cure right. And I'll ask it rhetorically, what is that amount of money with the payment of the insurance proceeds? Well, it's not the $21,000 that the judge found, that the motion judge found. The evidence in these emails is, I think I'm getting $11,000 as a $5,000 deductible. I'll pay you the $6,000. So how does he get defaulted for not paying $21,000 when on the terms of the default notice that comes out, the most he could ever owe is $6,000? And in fact, and I'll get to in a moment, he doesn't in fact owe that money because the insurance, this is an insurable loss. It's an insurable loss under the waiver of subrogation provision. It's on the landlord to cover this. But again, Mr. Greenberg is just trying to buy peace. And this is well before the COVID pandemic hits us, because that doesn't kind of really start taking shape until December and January. This happened back in June at the time. But as I say, the accuracy matters because we have to know what we're going to pay and what we're going to cure. And on the four corners of this default notice, what do I owe? If I owe the insurance proceeds is what it says on its face, well, I guess that's maybe $6,000. Well, then how does the judge find $21,000 and he defaults us for the $21,000 when it clearly is not what the evidence is in the record on that? They raise a new argument. Let me get to the emails, Your Honor, as you're referring to. At page 24 of their brief, they raise the argument, well, it was a course of dealing here. And while I guess they should have known, even though that the default notice says something different. The default notice says insurance proceeds. It doesn't say pay the work order billings. I understand they were attached. In any event, it lacks formality. Can we go back to what does the lease require? The lease requires that if you're going to tell me I owe those work order billings, and you're going to send me in an email, not good enough. You have to send it to me under the terms of the lease, which is in writing to me, by mail, and to my lawyer, copy my lawyer on it, have to send it to the address, have to send it to my notice address, and you have to send it by a very specific means, which is the certified mail or the overnight mail.
Now, see, your argument might have slight more merit if your client actually paid the $6,000. He didn't, right?
He did not.
So if one side thinks you owe $21,000 and the other side says, well, I'm going to pay you the insurance proceeds. I've got the check from the insurance proceeds. It's $6,000, and he paid that. Well, then your argument might be that's what I thought I owed.
Well,
but he doesn't pay.
He did not have a check for the insurance proceeds at the time the default notice came out. That didn't come until later on. It is a lost, his email's on a lost check, and where is it? I'm told by my broker it's coming and whatnot. But he didn't have it. But the fact of the matter is when we finally get to the seriousness of the default notice, and it tells us, and my lawyer's now involved, and it tells us, you owe me the insurance proceeds, there's no requirement in the lease. If they think he made an agreement to do that, they can sue him separately for it and say you owed us that money, that was an obligation you took on. He does not amend the lease to include in payment insurance proceeds when, again, he's just trying to buy some peace and some back and forth that comes with it. Let me say this, where should the risk of loss fall? So when we're looking at the lease, we're looking at a default notice comes out, and it's inaccurate. It says something that the lease does not require, and where should that risk of loss fall? If it's on the tenant really has no choice but to say, I don't think I owe this. But, well, they've given me two reasons. I have to pay it. Should he have to come out of pocket to pay it? What if they put 10 reasons in, and maybe one of them sticks over time? You're encouraging a laundry list of items in a default notice. Default notice has to be accurate. We have to know exactly what we owe to cure. And when we get up there to pay it, that risk of loss, if it falls with the landlord, if it falls on the tenant, arguably loses the tenancy. It's actually what happened here. Loses his entire tenancy, loses his lease. If it falls on the landlord, well, it may cost them a month or two. They go to summary process. They realize, okay, I've had a ruling against me that it's not, in fact, an obligation under the lease. But what happens is they just get to restart again. And we don't surrender the tenancy because of the default notice. That risk of getting it right needs to be on the landlord. It shouldn't be, well, to the tenant if it's close, good enough for us. Let me get to the rent being the second reason that's in there. The frustration of purpose is addressed, and I think very well, by the motion judge, Judge Salinger. I will not go into detail with it. I do want to talk briefly, well, let me actually, one comment, I guess, on that. If the motion judge finds under this notice, now it has two components. One is the insurance, even if you want to call it even if you want to say it's the payment of the grease trap, about $125,000 that notice is rent. Judge Salinger decides in our favor and says that money is not owed. How is that default notice now still a valid default notice? The money's not owed. We were able to show that. He just simply goes beyond that and says, even though 85% of the monetary claim is no longer due, I'm still going to assume it to be a valid default notice. Again, back to the risk of loss. Who should bear that burden? If you have one thing on that default notice that is not accurate, and we were, so far in this proceedings, have proven that was not accurate because that money was not owed, that should now require the tenant, that's an invalid default notice, that require the landlord to go back and do it. Let me address just very briefly the casualty and taking. It's also briefed in my papers as well. It really simply comes down to this, and the issue that has been presented, and it's with both Judge Salinger and also with my brother who's raised the issue, is what does damaged mean? Does it have to be physical damage? And the only thing I'll say to you on this, and very briefly, is it is a category of damages that is defined within the four corners of it. It tells us damages could be, because it says, by fire, unavoidable casualty, or by action of any public authority or other limitation, other authority. This is a very unusual provision in a lease. I will tell you, I looked far and wide to find another one. I couldn't find it. I know my brother looked far and wide because he cites cases from Virginia and Illinois, and he can't find it that's out there. I'm asking the court, interpret the lease itself. Don't look to these other cases. The motion judge went to the Verveen case. There's no question the Verveen case was interpreting a insurance policy, and that does require physical damage. That's the law of the Commonwealth, has been for years. This is a lease. It's not an insurance policy. Similarly, the cases that are lease cases that are cited by K&H, those lease cases deal with classic casualty and casualty policies, terms that
I just want to make sure I'm understanding your argument, because I think I agree with you that we can resolve this by reading the language of the contract. That's obviously where we start every time we have a contract case. So I'm looking at page 128 of Appendix Volume 1, the beginning of the casualty and taking section. And the first sentence is, in case the premises or building or any substantial part thereof shall be taken by any exercise of the right of eminent domain. Can we all agree that didn't happen here?
Correct, yes.
Okay. Or shall be materially destroyed or damaged by fire or unavoidable casualty or by action of any public or other authority. That's what you're talking about?
Yes, exactly.
Okay. And you maintain that the language shall be materially destroyed or damaged by fire or unavoidable casualty or by action of any public or other authority applies to this case.
It does. Hey, I'm sorry, I didn't mean to cut you off.
We can agree that the building is still there.
Yes,
There was no fire.
there was no fire.
I think I walked by it this morning. It looked okay. Not materially destroyed.
Correct.
So please explain to me how that sentence supports your argument.
So the question is materially damaged, and then skipping over the fire, because those would require physical damage, by action of any public authority. And the issue then becomes this, and it's the premises I'm referring to, not the building. The premises in which the restaurant was run, was it damaged by the public authority? When you take away the use of it, you have damaged the ability to use it. The use is very specific in the lease. It is for table service restaurant only. During the period of the shutdown of the COVID, that was shut down and was not allowed to be used. Again, this is a lease provision. There's nothing in here that talks about physical damage to it. That's an insurance concept. And this is very specifically was damaged because its use was taken away for a period of time. I'm not saying it was an actual physical taking by the authority with compensation, but it was not allowed to be used for that period of time, and that damaged the use of the premises. It's all about the use. With regard to Let me just hit very briefly the guarantee. Let me turn to the guarantee. I'm running low on time. The guarantee itself, the motion judge makes a finding that Seth Greenberg personally guaranteed payment of any and all amounts owed by High Street under the lease. It does not say that. What it does say in paragraph 1A, it says obligations, and it's terms right out of the lease. It's minimum base rent, percentage rent, real estate taxes, utility charges, and late fees. Guarantees, as you know, I cite a 100-year-old case. They're narrowly construed, and they have been for the last 100 years. And the issue here then is, well, what happens when the lease is terminated? They did not have to terminate the lease. That was an election that the landlord made. When the lease is...
Counsel, you're running out of time. Can I go back to something
Yes.
you just said? Are there any cases, obviously post-COVID, where a company, restaurant owner, whatever, has been not had the obligation to pay under a lease because of COVID? I mean, this has happened in many different properties during COVID.
The law of both LaForte and the Inland case, it says that it is an abeyance or a staying of the amount that's due. It is then, you go to the restatement, it's a reasonable period of time thereafter. We were dispossessed, and we were dispossessed because they sent notice to our bank. Our bank exercises security interest. We couldn't use the tables, the chairs. They froze our bank account. We couldn't pay our employees.
So under the state of the law, post-COVID, it was the amounts are still owed, but they're stayed until whenever.
Yeah, so with a reasonable period of time, and that's obviously open to interpretation, but a reasonable period of time after you open, you can't pay the first day, even close for 90 days. You haven't made any income over the period of time. Let me just focus on the guarantee, Your Honors. And it is, the guarantee has very specific language. 275 Washington Street, which I cite in my brief, says the proposition is if you terminate the lease, you terminate all the obligations. The restatement second, which is cited in that case, says that the rent, capital R rent, is no longer due under the lease. And you go forward and you have to specifically hold back and identify what is owed. In this case, the only thing that is guaranteed under the guarantee is the capital R rent and similar types of obligations, and those were no longer due under the lease. I see I'm just about out of time. Those who are doing the lease, my last thought, if I can just simply finish with those who are doing the lease, they didn't have to terminate the lease. They'll tell me it's an intent. What do they mean? It makes it meaningless. It doesn't make it meaningless. They could have simply defaulted them, sued them for 6 months, waited another 6 months, sued them for another 6 months. Mr. Greenberg would have been liable for those damages.
We'll leave it with the briefs. Thank you.
Thank you.
Good afternoon. May it please the court. Brian Lee for the trustees of the K&H Realty Trust. By the time K&H terminated this lease on July 30th, 2020, there were actually 3 separate events of default that supported the termination. There was the failure to pay the pre-pandemic grease trap charges, the failure to pay anything after March of 2020, and this failure to open, which has not been discussed yet today.
Was that,
Third one, I'm sorry, I didn't hear the third.
The failure to open for business.
Okay, thank you.
and was that part of the notice of default?
So it was not referenced in the notice of default. It was also not referenced in the termination. I'm happy to get to that. That is essentially their fundamental defense to that claim here. I will tell you the notice of default for this termination payment, there was no cure period, no notice required. Failure to open for business is a per se event of default, so you don't actually need a notice for that portion of it. But focusing first on the grease trap expenses, if I may, we just heard that the primary challenge is to the notice. And Justice Hershfang, you correctly noted that this reference to the reimbursement of insurance proceeds is because that's exactly how Mr. Greenberg was framing his payment at that time. He was saying, I will pay once I get my insurance proceeds. Now, we heard about this $6,000, $11,000, and I actually don't think there's anything in the record suggesting when these payments were received. But we do have, I would point to, Mr. Greenberg testified, I think this is in Record Appendix 192, and did you at various times and various emails agree to pass some or all of those proceeds along to the landlord? I did. We also cite in our brief the various instances where this was discussed. There was never any dispute that Mr. Greenberg would be paying these amounts. And in fact, he admitted at his deposition the only reason he didn't pay them was because of the financial struggles the business eventually had. This entire evidentiary record undermines this after-the-fact attempt to avoid payment. Now, getting to the default notice specifically here, the lease requires that K&H provide written notice of any charge that's past due. That's it. And then the purpose of that is the tenant then has a 10-day cure period to fix that. There's no magic language required here. It is simply so that the tenant does not mistakenly, it's a negotiated for a contractual right, does not mistakenly not make a payment and then lose their lease over that. Here, this payment had been demanded for almost a year at this point. When K&H finally served its June 16, 2020 default notice, as we discussed, it referenced the reimbursement of insurance proceeds. It also referenced and attached an age delinquencies report, which itemized each of these grease trap charges, date, amount, and it did that. That was provided in the exact same form that had been provided to Mr. Greenberg previously when discussing these grease trap charges and the amount owed. I'd refer to Record Appendix 1307 to 312 and 394 to 395 for two pretty glaring examples of that. There's no evidence at all that Mr. Greenberg or anyone else at High Street was confused about this notice or didn't understand what charges were being referred to here. Mr. Greenberg simply chose not to pay because of his financial issues. That's not a notice problem, that is a refusal to pay. Turning very briefly to the subrogation waiver argument, first of all, there's no evidence in the record at all what K&H's insurance policies provide or what a standard insurance policy would provide here. And what they're actually doing is conflating the obligation, the contractual obligation of High Street to pay K&H for these grease trap cleanup costs with the limitations on an insurer's ability to pursue a subrogated claim against High Street where K&H can submit an insurance claim for these charges. Under their interpretation, there would never be an instance where High Street would have to pay these grease trap cleanup costs. Section 1709B would be entirely written out of this lease. That is not the intent of the parties. There's no evidence in the record to support this. I do want to turn to the second event of default, which is the failure to pay the post-pandemic charges. And while my brother was brief with the frustration of purpose argument piece, I actually think this is an important part of this case. And respectfully, I do disagree with Judge Salinger's decision in the trial court that the frustration of purpose excused their failure to make any lease payment after March of 2020. The inland commercial case that this court decided, this court actually declined to follow a different Judge Salinger decision on frustration of purpose, the Cafe Nero case, made very clear that frustration of purpose is a narrow doctrine. It requires that the purpose of the lease be completely frustrated. The vast majority of courts have declined to apply the doctrine to these temporary COVID shutdown orders, and that a temporary application of the doctrine only suspends, it doesn't discharge this obligation. Here, we are talking about 3 months in the middle of a 15-year commercial lease. Throughout that time, High Street could have continued to operate. It physically could have because it was in possession of the property. It had over $400,000 sitting in a bank account from a PPP loan. And it also could have continued to operate under the lease. The permitted use section of the lease authorized High Street to use the premises as an upscale table service restaurant, a lounge, bar, and or an event space, and all ancillary uses there too. It also expressly included outdoor dining. Now, High Street's shutdown orders had decision to shut down had nothing to do with the governor's COVID-19 orders. They shut down before those orders were even issued, and they refused to operate within the permitted authority once they were actually issued. So they could have still offered takeout as they had done before the pandemic. They still could have offered outdoor dining as of June 8th, 2020, as they had before the pandemic.
Counsel, I'm sorry, I'm going backwards.
Certainly.
Can I go back to the payment on the notice default? The notice of default says fixed rent and additional rent due for the months of April, May, and June, and the reimbursement of insurance proceeds for work performed, blah, blah, blah.
Yep.
Isn't a reasonable reading of that even though, landlord, you say we owe and I'm looking at the schedule, I hope I got the right amount, $22,757. If you only get $5,000 from the insurance proceeds, that's what you owe us.
Well,
Isn't that a reasonable reading of that?
Well, I don't think so because of the age delinquencies report that's attached to it, and there is evidence in the record, which is not limited to
I guess
5.
I'm asking, why does the notice of default say anything about insurance proceeds? Shouldn't it just say, you owe us $22,757.33, because that's what we've paid on the grease trap?
Right, and because the reason it did so is because that's how they're trying to appeal to Mr. Greenberg to actually pay these amounts. He knew exactly what he was talking about, these reinsurance, reimbursement of insurance proceeds. He was there's a lot of communication in this record showing that K&H's property manager, Farley White, was asking for these payments repeatedly. Mr. Greenberg would say, oh, how much do I owe? And they'd send him this age delinquencies report that details all of these. And then he'd say, okay, I'll pay you when my insurance company pays me. There is evidence in the record also that K&H said, we don't accept that. We're not agreeing.
Why did they say that?
Because they were trying to get what they could from him at that point. So even if we limited this to the amounts that are owed, that the insurance company paid. And to be clear, what the insurance company paid here was the full amount of the claim. It was $21,000 reduced to $16,000 because of a $5,000 deductible. So they paid the full amount on that claim.
And after this notice of default was sent, did he pay anything?
No, never. At any point did he pay.
So even if you take the lower number and say, just give us what the insurance is, that still is a valid
Correct, Your
notice?
Honor.
Okay.
Correct.
Just wanted to make sure that was clear.
Yep. So I want to come back real quickly to this. Mr. Greenberg and High Street could have operated. Mr. Greenberg chose not to do so. And he chose not to do so because he didn't think it'd be profitable. He admits this in his deposition. He admits this in his contemporaneous emails at the time. And we cite too, and I want to reference a June 8th email that I think really illustrates what was going on at this time. My client learned that Mr. Greenberg was reopening on June 8th. There was a social media announcement that his Serafina restaurant in Back Bay was going to reopen for outdoor dining, takeout, and delivery. My client reached out and said, why aren't you reopening High Street? His response was, we need to lock down our rent with you to see if this is even feasible for now and see what the office scene looks like. We don't want to open High Street too early and lose money. That's not a frustration of purpose. That's an effort to maximize your profit and renegotiate your lease. Now, I do want to address really quickly I do want to briefly address what happens if this court would apply the frustration of purpose temporarily here, because I think the result is still the same. So, as this court has made clear, a temporary application suspends, it doesn't discharge. So, once this event causing the frustration of purpose is over, then the months that haven't been paid are owed. Now, my brother references this reasonable time frame. I'm actually not sure. That comes from the restatement. I'm not sure the court has actually, any court in Massachusetts has ever expressly adopted that part of it. But even if that's part of it, I think we see what a reasonable time frame would be. To the extent we're talking about a large construction project, obviously there needs to be more time. There's more buildup that gets into that. Here, I think we're literally talking about calling up some employees, getting them back in, getting food in the place, and we see what that time frame is from his reopening of the Back Bay restaurant between June 8th and June 10th. I would submit that's no more than 2 days. That's all it took him to reopen the Back Bay restaurant. I don't see that there's any reason why it would be different here. So if we're talking about June 8th, when the event is over, and based on the fact that he can reopen outdoors at that time, I still think those amounts are owed before this June 16th default notice. What they argue is that the date should actually be June 22nd, because that makes our notice premature, and they claim that invalidates the whole thing. We do cite to the Shawmut case from this court to say that with regard to these commercial default notices, the landlord's not required to serve them if it would amount to a useless gesture. Here, K&H continued to demand payment after June 22nd. Mr. Greenberg continued to refuse. And in that instance, where we've already served a default notice, he's continuing to refuse to pay. any sort of further default notice would fall within this useless gesture category. Very briefly on this failure to open for business, their defense is essentially that it wasn't referenced in the termination notice. I think I've already addressed that it wasn't required to be in the default notice. All the termination notice had to do under Article 13 is provide notice of the termination. I'd suggest there's no case, no commercial case, leasing case in Massachusetts that has ever held that a landlord is required in that type of scenario either to describe the bases for their termination or that they're limited to any bases described in it. So,
Can I pose the same question that I posed to opposing counsel?
Absolutely.
Because there have been many cases since COVID.
yep.
Putting aside the grease trap issue, if it's solely a matter of rent, what did COVID do regarding lease requirements for rent?
Well, I think
Under the case law that has come out since COVID.
Certainly. I'm not aware of any case that has excused a restaurant tenant from doing something like this. And I think the Laforte decision out of the SJC actually said that the pandemic itself did not result in any frustration of purpose event. And so I don't think the pandemic itself is even argued as being the basis for that. It's really these shutdown orders. Now, there has been no case in Massachusetts, certainly at the appellate level or above, that has had that type of holding where a restaurant is excused. I would actually refer to the Kritzko case. It's CRITZOS out of Maryland. It's a Maryland appeals court case. It is cited in our brief, although under the casualty and taking provision. There, the court addressed a bistro where the tenant was arguing that because of the shutdown orders in place, this frustration of purpose event existed. The court said no, because you could continue to provide takeout, the lease did not prohibit that from happening, then there was no frustration of purpose. And the termination of the rent was owed during that time, and the termination based on that was proper.
But under your argument, if I followed it correctly in your brief, even if the restaurant had opened, I mean, they owed, again, according to the schedule, $141,000. Let's go back a little bit where I think the rent was May. Let's take out May for a second. So we're down to $120,000. If they had opened, there was no way they were going to make as profit $120,000. If they owed anything,
Yeah, but
they're out of luck is what you're saying.
But the Laforte decision actually in that case I think is particularly on point there. That was a franchise agreement where the court said that those types of arguments did not trigger frustration of purpose because the payments weren't based on the profitability of the company. So it's not a purpose of the lease and that is the case here too. These are fixed rent payments that are owed regardless of the profitability of the company. And so I don't think the frustration of purpose would apply there. I see my time is up, and so unless there's any questions, I'd rest on my brief.
Thank you. The case is submitted. With
Thank
that,
you.
we'll close the hearings. We want to thank the court officers and our excellent timekeeper and everyone. Decisions will be forthcoming.
Court, all rise.